Just enlarge it.
Yeah. Ooh.
And then there's your Hi, Commissioner O'Brien. How are you? Nope, can't hear you.
I'm okay. You?
Good.
How you'll probably be discussing it, but what's the status right now of the two new commissioners? And what process?
I will discuss it as soon as we have a quorum.
Okay. Okay.
Yeah.
Amy, you should have the lit memo in your inbox now.
Thank you, Kit. Did I imagine that? It was in that
Would
drive.
it be in the business session folder?
Okay.
But I created that because it wasn't in there, so I don't know actually if everybody has access to it.
Well, I saw it before.
Okay, so yeah, it should
So
be.
I think everybody has access by default for the primary folder. So if you could see anything in there, then you added it. It's able to be seen by the default settings.
Okay.
That made no sense. Sorry.
That's okay.
I'm
It's the lit
waking
memo.
up.
That was in there before, right, Mel? I remember
Yeah, it's in
seeing
there.
it.
It's
Okay.
in there.
All right.
Jane needs to probably remember that that's what we pull from for the archive. So even though she emailed the commissioners her report, that needs to go in there as well, or it won't be copied to our repository.
Okay.
I
She
couldn't- I was
is not
looking-
here this morning. Jane isn't going to be
I'm
on the
gonna try
call.
to find it in my email and save it there myself, but I just wanted to remind people that that's
Yeah.
used for permanent record purposes.
Got it.
Thanks.
Yeah, we forgot to create an executive session. I forgot to create an executive session. Oh yeah, there it is. Yep. There it is.
For some reason, the template has all the executive session people, but when I use it, it doesn't populate the executive session room the way it should.
Yeah.
Unless
that's
it only
right.
shows people that are present when you're trying to select from it.
I
Maybe
think
that's,
that is it. It only selects who's here
yeah, okay.
because I've tried the same thing.
You know,
Once
guys,
show up.
you could be speaking Greek. Wow, Melody, you amaze me.
She is
Aw.
amazing.
Thanks, Julie.
She is amazing. I just created an executive session folder just to put Kit's memo in. Morning, Commissioner David. Good morning, Commissioner
morning.
Ashby. Morning.
Good morning.
Morning.
Amy, I've been having a little trouble with sending emails. Did you get my email yesterday afternoon about a time problem this afternoon?
No, I did not.
I've got to run something down. I may have to leave as early as 2:30. I have a home health nurse coming to the house between 2:30 and 3, so it may not be till 2:45 or 3 or something like that. But I need to see her. I'm in the healing stages of a major cancer surgery on my thigh. It was fairly dramatic, and she comes to, but I need to see her. So
Okay.
that's the time schedule.
Well, then we will push through as quickly as we can in the afternoon, because without you, we don't have a quorum.
I understand.
Yes, I'm so sorry to hear that you've been sick.
Well, it's been quite a haul.
Yeah.
I got to see
Well,
what happened to that email. I sent you an email with an explanation of what I was going through.
I don't doubt that you did, but I think you may be right that you're having email trouble.
It's in my sent folder, and I will try it again.
Ed and Julie, while he looks, did you folks have an opportunity to see an email from Amy this morning with the August meeting minutes?
Yes, I did.
Okay, good. So we'll be able to move on those minutes at the beginning of this meeting?
Yes.
Okay, great.
And I think I looked, I think it was in the folder. I did get to look this morning. I think it was, but I'm not 100% sure. But I'm glad everybody has it now.
Well, thank you for sending it. I'm the first to admit that I don't always navigate the folder as well.
Yeah.
But
It's hard on those
I
little
couldn't
computers
find it.
that we give you. On the
I'll
little
just-
computers we gave you, it is hard. And also, we were just talking, Melody and I, about folders and things. And Julie said, you might as well be speaking Greek to me about it.
I think unfortunately, it's probably because it's in a Google Doc. but
Yeah, I think that's right.
I'll
yeah.
fix it.
Yeah.
And add it in anyway.
Yeah, I think because it wasn't a PDF, maybe that didn't transfer over or something. So I'm glad. Thank you for reaching out, Jeff, beforehand, so I could make sure everybody had it. So we got 4 cases in the afternoon from 12:30. I think we should be okay, Ed. I think we'll be all right. But thank you for the heads up. Whoops, I just accidentally made Colin Hurd an MHRC commissioner. Whoops, sorry. I'm taking that back, Colin. I'm renaming you. Promotion already? Yeah, you're a good one. That's good stuff, Colin. Thanks. Promotion denied, withdrawn.
Not that that ever would happen again, but the minutes are always on our website after the meeting on the homepage in PDF.
Still didn't come to you, Amy?
I did get it now. Yes,
Jeez.
I got it. I got 2 emails, both received 2 minutes ago.
Yeah. I just forwarded the one I wrote it yesterday afternoon. It gives you a little more of an explanation.
It
but
does. Wow.
Yeah, life changes in a flash, folks. In a flash.
Yeah.
Got an autopsy. You got
an autopsy? Wow, you're looking great.
Well, got a biopsy of of a sort of inconsequential little hard spot in my thigh, and it turned out to be a somewhat rare and aggressive cancer that
Wow.
has started a long journey.
Wow, Ed.
Yeah. So,
Wow.
and
That
I'm
does put things in
Ed?
perspective, right?
I'm
Ed,
halfway.
I just
through.
want to remind you that we are streaming and
This is
recording
public.
this to the world.
Well, that's all right.
Okay, I
I
just
told-
wanted to make sure you were okay with it.
I'm okay with it. No, I'm halfway done. I'm recovering from the surgery, and then we're going to do radiation to finish off those pesky little cells and go on with life.
Wow.
And
But
if you don't mind me asking, like in your thigh, like what type, bone or?
No. In the fleshy area above the muscle, fortunately. So
Wow.
the surgery didn't take any muscle, and I walk for exercise. So that's why we thought it was just a fatty deposit and sort of ignored it for a while. But it also does, Amy, I'm not sure what our schedule is on our new commissioners. I mean, I saw the emails and the possibility of a session to confirm them. I
Yeah.
will probably be in radiation in October.
Well, luckily we don't have a meeting in October, so you are in the clear.
There you go. Everything's
I see you,
falling together.
Jeff. Jeff, I see you trying to start. Love it.
Okay.
Keeping us on track.
Sorry.
Good morning. Good morning, I'm Jeff Ashby, and on behalf of my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking that each of you who may have an electronic device to ensure that they are silenced now. The best thing to do is, if you're not speaking, to mute yourself while we're here on Zoom. We have additional agendas, including the consent agenda, available electronically, right, Amy?
Yes, it is on the website.
Yes, the consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted period, and the commission has voted on those cases, and they will not be considered further today. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that that unlawful discrimination has occurred. The commissioners have received investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order on the accepted agenda. Occasionally we go out of order for reasons that are unique to the cases, but ordinarily cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium to provide the most relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only 1, relevant factual errors, 2, relevant omissions from the report of facts submitted during the investigation, or 3, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. Please be advised that commissioners may ask you questions, and I'll ask that you introduce yourselves as you come to the podium. Thanks.
And Jeff, if I could just add 2 things. One is, I think that welcome said in there that we've already voted on cases on the consent agenda, which we have not. I think that's usually the speech that we give part of that after we've done the business session. So we, just in case anyone is on here to watch the consent agenda or is watching the live stream, we have not yet voted on the consent agenda, but we're going to shortly.
Right.
Actually, that's the only thing. Sorry.
Yeah, I thought that as I was reciting that we
I saw you pause briefly.
have yet to vote, but we're going to do it right
Yes.
now, actually.
Yes.
All right, let's start our work here today with a director's report. I'm sorry, with a adoption of the consent agenda. Let's do it now. Let's adopt our agenda and our consent agenda. Can I have a motion?
Move adoption of the consent agenda as published.
Second.
All right, it's been moved and seconded.
So it's been moved and seconded to adopt the agenda and consent agenda. And just to remind folks that when we are meeting remotely, we are required to have every vote be taken so that people watching can both see it and hear it. So I will have to poll commissioners for every single vote and need to see you and also hear you. So If you're in favor of adopting the agenda and consent agenda, commissioners, please say yes when I call your name and also put your hand up. Commissioner, and I'm going in order of seniority on the commission. Commissioner Ashby,
Yes.
Commissioner David,
Yes,
Commissioner O'Brien.
Yes,
Thank you.
Next, I'll entertain a motion to adopt the minutes of our August 2022 commission meeting.
move adoption of the August 22 minutes.
second,
It's been moved and seconded. Any discussion? Keep forgetting discussion. Seeing none. If you are in agreement with adopting the August 2022 meeting minutes, say yes and put your hand up. Commissioner Ashby,
Yes.
Commissioner David,
Yes,
Commissioner O'Brien.
yes,
Thank you.
And now our director's report.
Now, it will be brief. You do not have a personnel memo from me because there is nothing to report, which sometimes I make too many comments about when the few times that happens, and now I'm just going to keep my mouth shut because it's awesome. For compliance, you have a memo that purports to be from me, but is really from Jane O'Reilly. The status of pending cases. There were no successful conciliations in August. There's no unsuccessful conciliations in August. There are 4 cases pending in conciliation. There are no conciliation agreements for you to review this month. For investigation, you have a memo that shows 29 complaints filed in August, 11 administrative dismissals in August, and either predetermination settlements or withdrawals with benefits. There were 6 of them in August with benefits of just over $80,000 to complainants. Litigation, I would ask that we take after executive session. New business, again, not that much. We have submitted our biennial budget proposals to the administration, and I think we meet with them at some point, probably in October, I imagine, to discuss them. Both Barbara and I attended conferences. Barbara in LA, as you saw at our last meeting. Jane O'Reilly and I attended an EEOC conference in Providence last week. The only other thing is I was asked about new commissioners. As I emailed you all, which is okay to email because we weren't discussing anything or voting on anything. The governor did propose 2 nominees. She nominated 2 people for vacant commissioner seats, and Mark Walker of Hallowell and Tom Douglas of Cumberland. They both had Judiciary Committee hearings last week, both of them unanimous votes to confirm. The next step for each of them is that they need to be voted on and approved by the state Senate, but it is not in session. So we are waiting for the governor to call a special session. And I haven't seen a call to go into session yet. So hopefully that will be happening soon.
Saw a letter that she sent out that is supposedly calling one for tomorrow.
Oh, there you go. Good thing
So
legal's on board.
supposedly everybody will be up for confirmation tomorrow.
Oh, excellent. Thank you, Barbara. So that means those folks should be able to attend our November meeting, which is fantastic because then we'll have 5 commissioners and we don't have to worry so much if one person has to leave early for something else. So that's the status. And that's all I have for new business.
Well, great. Then we need to wait 7 minutes
We have a 7-minute break.
and we'll be back, folks.
Um,
Call the first case.
Oh, sorry.
is it possible to do executive session right now, since I have something that we need to discuss before Ed leaves in case we're running late this afternoon?
Sure.
If not, we can do it between sessions. Doesn't matter.
I think we will have time. It's up to you commissioners, really, if we can do it quick so that we don't delay the hearings
Sure.
this morning.
Sure. I move that we go into an executive session to discuss rights and
cite the
duties
statute.
of council.
Got to cite the statute.
I don't have it in front of
Pursuant
me.
to 1 MRS section 4056E, a friendly amendment to
Accepted.
my fellow commissioners' motion.
So moved.
No, we need a second. Julie, we have to hear you.
No, second.
So it's
Like,
been moved.
no.
Been moved and seconded to go into executive session. If you're in agreement, I need to see you and hear you say yes. Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner O'Brien.
Yes.
Okay, I will zip us into executive session, and for all the other folks, please don't leave. We will be back very shortly and hopefully in time to start on time at 8:45. All right, let's try this. Hold on. And we're back. Commissioner David,
I move we approve the proposed settlement at E19-0260 Champaign versus Walmart and authorize either council or executive director to execute settlement.
Second.
all right, so it's been moved and seconded to authorize, to approve the proposed settlement of E19-0260 and to authorize either Barbara or me to execute that. It's been seconded. Is there any discussion? Oh, Julie somehow. Hold on, let me get Julie back.
Oh. Here she comes.
Yeah. All right, Julie, so you're back. Okay, so it's been moved to approve the settlement of E19-0260 and to authorize either Barbara or me to execute that. It was seconded. Is there any discussion? Seeing none. All commissioners, I'll poll you. Need to see your vote visually and hear you. Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner O'Brien.
Yes,
Okay. And then we have one more motion and we should be good to go for the hearing agenda.
I'll move that we not litigate cases in E200157 and E200242.
Second.
Moved and seconded to not litigate those two reasonable grounds cases in which conciliation was not successful. Is there any discussion among commissioners? Seeing none. If you are in favor of not litigating those two cases, please vote yes, visually and auditorily. Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner O'Brien.
yes.
Okay. So we are set on those things, and we appreciate everyone's patience as we jam those things in to make sure we have a quorum. Okay, so I think Commissioner Ashby, we are ready to begin the hearing agenda, the morning session.
Calling our first case, E200368 Williams v. Serve Pro. Let me find my case. This was a no reasonable grounds case. And so is there a representative of the complainant here?
Yes, Riley Fenner here for the complainant.
All right. Mr. Fenner, you can begin anytime.
Thank you. And really, I am here this morning only to inform the commission that the complainant does not intend to pursue this matter any further at this time. And this is due to the terms of a settlement agreement in her workers' comp regarding her claim for workers' compensation benefits, which is expected to be finalized later this week. I only heard about that from the attorney who's representing Ms. Williams in that case on Thursday, and only got things squared away with my client on Friday. So I apologize for the last minute turnaround here, but I will not be presenting any further arguments due to that expected settlement. And as I say, the complainant does not intend to pursue the claims in this matter any further. I'm happy to answer questions that anyone has, though.
Except about the terms of the settlement, which are confidential.
So I have a question for Barbara. Does that constitute a withdrawal that it would normally be back on the consent agenda, or do we make a finding? Do we proceed with the case?
I think you need to make a finding.
This was not presented as a withdrawal because we got it so late, there wasn't time to present it. And I didn't have a signed withdrawal from the complainant themselves. So it is not a withdrawal.
Got it.
Thank you, Mr. Riley, Mr. Fenner, sorry.
You're welcome.
Well, I don't know that that requires a response from the respondent in any way, but we should say hello to is there a representative of the respondent here?
Yes,
Mr.
commissioners.
Franco. Yep.
Yes, commissioners. Mark Franco on behalf of the respondents.
Mr. Franco, I think it's our intent to take a motion at this time, unless for some reason you want to be heard.
No, I don't think it's necessary. We would accept Mr. Fenner's representations, and I will accept whatever the commission decides.
All right, I'll entertain a motion. Ed?
Well, I would suggest we forego the hearing from Alex, who was the investigator, did an excellent job, and I would move that we take them together and find that there's no reasonable grounds to believe that responded unlawfully discriminated on the basis of disability or retaliated for the filing of the complaint. That's E280368.
Is there a
Second.
second?
Second. I'm sorry, Commissioner Ashby, I just talked right over you. Did you second that?
No, I asked the same question you did. Is there a second?
Second,
So it's been moved and seconded. Is there any discussion among commissioners? Seeing none, if you are in favor of finding no reasonable grounds on both claims, you will say yes and indicate that visually as well. Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner O'Brien.
yes,
So the findings are no reasonable grounds, and the commission will send the parties a letter confirming that. And thank you both to council. There was a lot of emailing back and forth about how to proceed with this. So thank you so much for being here this morning.
Thank you.
Our next case is E200369. Forgive me if I mispronounce. It's Malter versus Northern Lights Eastern Maine Medical Center, and this is a reasonable grounds case. And so, is there a representative of the respondent here?
Morning, Commissioners. Megan Randlett on behalf of Northern Light Eastern Maine Medical Center.
Good morning.
And before folks start, I realize this was the one thing I was going to say before, but neglected to do so. If folks could not use the names of any people who are not named parties to a case. So if it's a supervisor or a nurse or whatever, we've given them pseudonyms in our report. So please don't use the names because I don't want to have to interrupt folks and say, don't use names. Thank you.
Understood. Thanks.
All right, Attorney
10 minutes.
So good morning, everyone. Again, Megan Randlett on behalf of Responder Eastern Maine Medical Center. I appreciate you taking the time to review this matter this morning. In an effort to respect everyone's time, I'm going to focus on what I believe are the factual and the legal issues with the investigator's report and recommendations. So first, turning to the factual issues in this case, when reading the investigator's report, I was very concerned to see that the recitation of facts left out what I believe to be significant portions of evidence that are directly relevant to and support EMMC's position in this matter. That EMMC had legitimate non-retaliatory reasons for choosing not to hire a complainant into a permanent position. Unlike many employment discrimination cases where there is often a lack of documentary evidence to support a party's position, that is not the case here. One need not take the word of either party over the other, as there is ample documentary evidence detailing both the rationale and the inner thinking of the decision makers and administrators at EMMC throughout complainant's time working there. By way of example and of particular concern, there is an email from EMMC management that was dated July 30th, 2020, which was submitted in evidence as Exhibit 1G to respondent's original response, that was not even referenced by the investigator's report, that explicitly details the reasons why EMMC chose to end complainant's locum's assignment. Notably, the reasons relate solely to complainant's demeanor and manner, not any reports of allegedly protected activity. This email put into motion the mechanics of ending complainant's locum's assignment. In addition to providing extensive documentation to support the decision-making in this case, EMMC produced 4 separate witnesses at fact-finding who all testified credibly and consistently that the decision to stop using complainant had nothing at all to do with any protected activity. One manager witness was in tears describing how complainant's behavior impacted her staff in such a negative manner. She effectively described that complainant was tearing the department apart. Also not mentioned at all in the investigator's report are the 7 secret recordings submitted by the complainant on the very eve of the close of evidence in this case. In one of these secret recordings, one of EMMC's managers was recorded during a meeting with complainant after she had found out that her locum's assignment was ending. In the meeting, complainant deceived the manager and attempted to set her up by recording her while asking her to address what she described as, quote, the elephant in the room, which complainant described as EMMC's decision not to hire her as an employee. The manager, who was completely unaware that she was being recorded, credibly stated that complainant was not being hired because of her behavior and that her inability to get along with staff and physicians was causing such issues that they simply could not move forward with a relationship with her. This evidence was not included in the report and does not appear to have been considered by the investigator. In addition to the investigator's failure to consider important facts and evidence, the most serious error with the report is the investigator's failure to consider complainant's credibility, which in a retaliation case such as this is a crucial aspect that must be considered as part of the burden shifting analysis. There is no mention in the report of any consideration of complainant's credibility. And as I mentioned before, there is no mention at all of the recordings that complainant secretly taped during meetings with EMMC managers and staff alike. In these recordings, as I hope the commissioners had a chance to listen to them, but if you haven't, you can hear complainant asking staff and managers to meet with her in private. You can hear her close the door or make sure that the door is closed. And then you can hear her proceed to speak with the individuals in hushed tones and ask them pointed and very specific questions designed to elicit responses that would be helpful to the case that she evidently planned to bring all along against the EMMC. These individuals did not know they were being recorded and certainly did not agree to be recorded. What is particularly telling, though, from my standpoint, is that despite complainant's deceitful and inappropriate actions, the recordings did not do what the complainant hoped to accomplish. And instead, they do nothing but to corroborate the evidence that EMMC has submitted in written documentation. What the recordings do show, however, is very telling. They show a window into how complainant acted on a daily basis while working at EMMC, including having inappropriate conversations, talking about other people behind their backs repeatedly, and talking down to people. By way of example, in one recording, which had nothing whatsoever to do with current clinical work, complainant tells stories about patients having sperm in their eye and patients having eye issues due to asphyxiation during intercourse. In multiple recordings, complainant goaded staff and managers to talk about others behind their backs, talked about rumors, and tried to get dirt on others. This is exactly the type of behavior that EMMC spoke with complainant about repeatedly, and the type of behavior that was cited by EMMC as a reason why they needed to part ways with her. Complainant also repeatedly brags about her training and experience in a manner which is honestly uncomfortable for a listener to sit through. She brags about her residency training and cites her training and experience to be far superior than all other physicians in the office. Again, this is exactly what EMMC was dealing with that caused them to elect to end her locums assignment. Complainant told staff in the office that she ran circles around her boss and her fellow surgeon. Complainant also accused another surgeon in the office of slander and reported him to compliance when he indicated his disagreement with her clinical judgment after she had asked him for his opinion on the very matter that she reported him for. In the report, the investigator found that there was, quote, at least an even chance that but for the content of her reports, she would not have suffered an adverse employment action. This is quite simply the wrong conclusion. It was an error to not consider the secret recordings as part of the investigation and decision in this case, and considering all of the evidence as well as the credibility of all of the witnesses, including the complainant, as must be done in a retaliation case, the overwhelming conclusion is that EMMC's stated reasons for deciding to stop using complainant services was only due to her behavior and had nothing at all to do with the content of any of the alleged reports she may have made. In conclusion, there is no evidence in the record in this case that EMMC retaliated against complainant, but there is overwhelming evidence that EMMC encountered many difficulties with complainant's behavior, that complainant's behavior had a negative impact on staff and fellow physicians, and that EMMC addressed complainant's behavior with her on numerous occasions. There is also extensive evidence in the record that any and all actions taken by EMMC in this case had nothing to do with any alleged protected activity and instead were solely based on complainant's unprotected conduct, such as gossiping with staff, talking down to staff and other physicians, both directly to them and behind their backs, and making inappropriate comments. It is for all of these reasons that I respectfully request that the commissioners reverse the investigator's finding of reasonable grounds and instead hold that there are no reasonable grounds to believe that EMMC retaliated against complainant for engaging in protected activity. Thank you for your time.
Thank you. Any commissioner questions for Ms. Randlett at this time? Commissioner Ashby? And then Commissioner
Thank you,
David.
Attorney Randlett. The secretly recorded conversations, the existence of them was not known to the respondent until well into the process after termination. Is that correct?
That is correct. We were not made aware of them until during, I think it was right on the eve of the fact-finding conference, I believe.
So the secret recording is not cause, but simply referenced by you to explain sort of what type of person this complainant is. Is that fair to say?
That's fair to say, yeah. I look at I think the importance of the recordings is really related to the complainant's credibility in this matter.
Of course, I don't mean to be facetious, but if it were truly a high quality WPA case, secret recordings are kind of the hallmark, right, of perhaps whistleblowers. I mean, it's not unheard of, right? That'd be a valid reason to record secretly some conversations if you weren't being, say, heard by your employer.
I suppose one could look at it that way, but I tend to think that it goes to the credibility of an individual if they're engaging this type of behavior, particularly where it wasn't the recordings. If you look at the dates of the recordings that were submitted, she began recording very early on, mid-June, I believe. So at that point in time, she was still, from her perspective, I believe she would say that she was still entertaining the possibility of working at EMMC, and certainly hadn't raised any concerns about, alleged retaliation at that time. So to me, it's unclear why she would feel the need to start recording secretly at that time and continue for the rest of her time there.
Well, as I understand the investigator's report, she was also, though, at that time, from very early on, making concerns known to her employer about conditions at work, whether valid or not. She was making those complaints early on, correct?
I believe EMMC would agree that from almost day one, I think she was reporting concerns. Yep, sorry.
I'm sorry. Well, no, go ahead. I'll let you finish, of course.
No, go ahead. You can go ahead.
I direct your attention to the first paragraph of page 3 of the investigator's report. Do you have that in front of you?
I do.
The timeline, as stated somewhere in the middle of that first paragraph, I want to ask you if the respondent agrees to the timeline. Is it the case that on July 2nd, you folks did extend the temporary employment contract to October?
So without looking back, that may be, if that's what's stated in the investigator's report, I believe that there were emails. The way that the process works, my understanding of the locums assignment, is that there are back and forth conversations with the managers of the locums company. And that at that point in time, on July 2nd, EMMC was still obviously utilizing her services. And as we stated, we were hopeful, EMMC was hopeful that she would turn her behavior around. So I don't disagree that we very likely did extend it until October, the locums assignment, with the hope that she would be able to kind of right size her behavior and that she would be a good fit for the practice and we'd be able to retain her.
And 18 days after she had that contract extension, she met, per the investigator's report, she met with a lead physician, a director, supervisor, and office manager about her concerns, the concerns she'd been raising as part of her WPA claims. Do you agree that that happened?
I agree that I don't think that I wouldn't see that as a tipping point per se. I would say that there were continual meetings with management through, I mean, every day, honestly, she was meeting with the managers to discuss issues. So I think in this case, there's no question that there's temporal proximity. We're not going to disagree with that, but to me, that's not the end of the analysis. That can't be the end of the analysis. Just because there's temporal proximity, there's a burden shifting analysis that has to be applied. And here, I think that EMMC has presented sufficient evidence to describe the reasons why the action was taken, which were not in relation to any of the alleged reports that she made.
So thank you for the acknowledgement about the temporal proximity, because I was going to walk you through the sort of last week of her prior to the decision to terminate. But I will ask you, on that July 20th meeting, it doesn't seem like, at least per the investigator's report, it doesn't seem like issues were raised at that time about her behaviors. It sounds like it was a meeting at her request or brought about as a result of her concerns in her employment.
Mm-hmm.
Would that have been an opportunity for someone to raise concerns about her behavior and her performance? It doesn't seem like that's indicated in the investigator's report, but do you have a different understanding of that meeting on July 20th?
I think that the July meeting that you're referring to was requested by the complainant to discuss very specific clinical type issues, concerns that she had noted, and that I don't think that the intent was to discuss the administrators and management at EMMC did not go into that meeting thinking they were going to discuss concerns related to her behavior with her. They took her concerns very seriously. And because of that, when they met with her, they took note of all the issues. And as we submitted, EMMC looked into the issues. They took all of her concerns very seriously. We don't, at no point did EMMC discount the concerns that she was raising. The issue all along, however, was that was not clinical. The issue was not clinical. EMMC does not dispute that clinically she was good. And honestly, if there weren't the behavioral issues, EMMC would have loved to employ her. It is not easy to recruit for a retina surgeon in Northern Maine. There's no question about that. So this wasn't a situation where they obviously took issue with the clinical concerns. They took those seriously. They investigated them. They took note of them. But what was also happening at the same time throughout the entirety of the time that she was there were these continual behavioral issues that kept coming up over and over again with not only staff, but also physicians. And one of the things, the July 30th email that I referenced, also happening at the same time, I referenced it briefly in my statement, but there was a situation that occurred at the end of July where the complainant requested she approached another physician, a new eye surgeon in the office, and asked him for his professional opinion on a matter. And in response to that, she didn't like his response, and she submitted a report to compliance, accused him of disparaging her, and that was one of the other issues that was kind of the tipping point for EMMC. So although she had this meeting in late July with EMMC, July 20th, there were issues that happened after that were the tipping point. There was a staff member that came forward that accused her actually of retaliating against her. And at the same time, I submitted the notes from the staff member, but the staff member raised 3 pages of notes regarding issues that have been noted with the complainant, including her asking personal favors of other staff members, allegedly retaliating against that staff member for reporting her prior, I think you saw reference to the materials, there was a George Floyd comment, retaliating against that staff member, slamming doors in people's faces. And it was at that point that EMMC, in conjunction with the issue with the new physician, just said, look, we can't do this anymore. The department is falling apart around us because of her behaviors, and we simply can't do this anymore.
Thank you.
You're welcome.
Commissioner David, did you have a question?
Yes, I do. Thank you, Attorney Randlett. A couple of questions. The timeline. Well, first of all, what's the significance, if there is any, in your mind, that it's a locum's contract?
So I submitted, I kind of reserved our position on that matter. That was my intent in the documentation. I think the significance, I understand the commission's position. I believe it to be that effectively the commission would treat her as an employee for purposes of the Maine Human Rights Act. I think the significance for EMMC was that I mean, she wasn't our employee at the end of the day. She was a locums. She had a separate employer that was employing her. With that said, however, in the day-to-day dealings with her, EMMC treated her raising concerns of a clinical nature, treated her just as if she would have been an employee. They investigated everything thoroughly. They certainly did not, ignore things she was saying because she was a locums. And I think the significance is that just she wasn't our employee. She didn't ever get an offer of employment, and that was the intent of me raising that.
And I think we all agree that under the legal definition of control and working conditions and that kind of thing, she's treated as an employee and they can't illegally discriminate her against her. But from her point of view, she knows she's a locums. The report says that on June 1st, she sent an email asking if she could apply to for other positions, correct?
That's correct. And she specifically asked, she said she told EMMC that she had an offer on the table from another organization, and she asked if she should proceed with it. And EMMC met, internally by email and said, yeah, absolutely, you're free to proceed. We're not going to hold you. What the EMMC would have been able to hold her to her contract, because as a locum, she's under a contract with us. But EMMC at that point said, we're not even going to hold you to your contract. You can proceed with outside employment if you would like to do that.
So after a question about the timeline, after a month at the end of May and June 2nd, she is told in a meeting that she's not going to be offered a permanent position if things do not change in regards to her behavior. Is that correct?
That was correct. Yep.
Is there ever any documentation of any meeting about improvements in her behavior?
No. In fact, it was the opposite. There was additional documentation that outlined continual issues with her employment.
And those were said to her?
Yes.
Okay. A question about those recordings. I did not see in your listing of the recordings dates. Are they all after June 2nd?
They are, let me just say, so the dates, they were kind of embedded in the dates. The investigator could probably speak to that as well, but my understanding is the dates were embedded in the titles of the recordings. So I believe
you said to us that they were mid-June, and I'm just confirming that.
Oh, I'm sorry. There was
you said that the first one was in mid-June. It seems to me significant if those recordings surreptitiously are made after she's been told that there are those significant problems.
There was one recording that was recorded on June 3rd.
June 3rd. Okay.
3rd, correct. That's the first recording between, it was, without naming names, it was a practice director in the lead position and the complainant.
What is the practices? The practice is a wholly owned part of Eastern Maine Medical Center. Is that right?
Correct.
Okay. Presumably there are accrediting ongoing agencies and evaluations of all of these things. Are there ever any reports by complainant to any other agency other than talking to the people in the practice about these problems?
Not that I am aware of.
Would you agree to my impression as I read the initial situation with a doctor leaving a practice, changing, staff not being trained, that it's a chaotic situation? Absolutely.
And as I think in the fact finding, The witnesses from EMMC did an excellent job of describing the context to what was occurring here. As not to try to paraphrase too much, but as they described it, it was not only a combining of two practices at this time, but it was
Right.
physical moving of the premises. So yes, I think it was very chaotic. With that said, I am not aware of any other compliance related concerns that were raised aside from complainant raising her concerns. No investigations by any outside agencies, nothing like that during this time occurred. So,
Well, no reports by complainants to anybody else.
correct, or other reports by anybody that I'm aware of.
Right.
to
Okay.
outside agencies. Correct.
Good. And you maintain that her presence continued to be, as you've characterized it, a toxic situation in terms of relationships with other staff.
Absolutely. I mean, it was just we couldn't find any staff members that she could actually work with, unfortunately.
Is there any, is that an unqualified statement? You couldn't find any? There's nothing in the record of anyone coming to her defense?
Not that I'm aware of.
Right.
What I meant by that was there was continual turnover. We kept trying different individuals to support her. There were retina assistants, and they are specialized. So my understanding is we went through at least 2 or 3 different individuals trying to find somebody that was a good fit with her. And at the end of the day, we just weren't successful in that.
What did you call that?
A retina
Support for her?
Retina assistant. It's a support mechanism. An individual that goes into the office ahead of the retina surgeon, speaks with the patients, acts as the assistant while the surgeon's performing services.
Okay, thank you.
You're welcome.
Any other commissioner questions for Ms. Ranlett? Seeing none. Thank you, Ms. Ranlett. Commissioner Ashby, I don't know if you want to see, I don't see Dr. Molterer. I don't see her name on the call. And I don't believe she's represented. I also realize I just said your name as soon as you put food in your mouth. So.
Speak, but
Okay.
I figured you were going to call.
Okay.
Invite the respondent, but I'll do it. Is there someone here from the complainant? I'm sorry, not the respondent. From the complainant, either the complainant or her representative?
I don't believe so. And the investigator didn't see anyone either for complainant. So Ms. Randall, you have about 2 minutes left if you want to use them. All set?
All set, thank
Okay.
you.
So then we would hear from the investigator. And I believe this is Ms. Levitt-Soni's first presentation to the commission.
Yay. Thank you. Good morning, commissioners. I hope all is well. I want to say this was not an easy case. When we say the 50-50 standard, it was a back and forth for me on this. There were thousands of pages of documents. There was so many listening to voice recordings. I stand by my report. It was a difficult decision. To me, it came up to the level of just the 50-50. And I will take questions. I know, I'll take questions. I think that's better.
Thank you, Heather. Any commissioner questions? Commissioner David.
Heather, thank you. Obviously a large and difficult piece of work, and I sympathize with your candor in saying that it's 50-50. I'm not sure that I'm I'm persuaded. I want to ask you that same question about that I asked Attorney Randlett. Is there any indication of in what I naively think of as whistleblower going to some higher authority, going to somebody on Eastern Maine Medical's board, going to some accrediting agency, making a complaint about specific procedures that are in violation of accrediting standards or standards of practice? Are there any?
So I believe she filed within at least 2 complaints within the EMC reporting system. But whether or not she did not go outside because she was told that that was the steps she was supposed to follow was internally. She was also made aware that the supervisor and manager were who she was supposed to complain to or if she had any issues. There was discussion with the lead physician also where she made complaints. There are emails back and forth at points where the lead physician had said, I agree with her characterization. Do you also agree that these are the issues the practice is facing? So they were aware of the issues and that she was reporting it. Are you saying that you feel like for the whistleblower protection that she would need to go outside?
No, I would have my knuckles wrapped by counsel.
Okay, I was curious.
I was looking for it because I would suspect that she would, but I agree that it's not legally necessary. Heather, how can you not mention those recordings in your report, given Attorney Randlett's allegation of what they are, and particularly in terms of the time frame? By what I mean of the time frame is that she's told June 1st specifically that her behavior is disruptive in this chaotic situation, that she's not getting along with people, that there's no leadership to try to get us through this difficult time. And then she starts making secret recordings. How is that not relevant to your evaluation?
Well,
It's because it's not in the report. Yeah.
Right. Well, first, I believe in a whistleblower protection act. A lot of this evidence we get is recordings. The recordings, when I listened to them, had no useful information other than the fact that she was recording them. And yes, you could see that she was trying to get them to admit that they were at fault. She felt very strongly that they had shoehorned her into a position of being the evil person when her position was, and I'm speaking obviously for a complainant, which I should not be doing. But when I interviewed her, it came across very clearly that she was very concerned with what was happening. But I didn't think that the recordings impacted her credibility. It didn't go to any weight. It didn't prove her case, but it also really didn't detract from it. In Maine, we're allowed to record, people are allowed to record one-sided conversations.
Oh, I understand that it's not, that the recordings are not illegal and she has the right to make the recordings. But after June 1st, when she's told that her behavior is a problem, she then starts to make recordings, presumably to obtain evidence that she's not at fault, and apparently she doesn't get any. And that's not significant, that she's not trying to engineer that?
So I understand what you're saying, but I felt that there was enough in the record. Like when I went through all of the documents and interviewing the witnesses, the supervisor, the manager, and that's why it was very hard. And in my report, I wrote, I had a very hard time separating out what was behavioral and what was reporting. They were almost married to each other, because as I was listening to the recordings, she would start with like a safety issue or something, and then it would go on to other things, and it would go back to other safety issues. And then you could hear the manager agreeing with her on some of it. You could hear the supervisor agreeing with her that, yep, these might be issues, and going back and forth. And it was just a very odd back and forth. There was no clear-cut smoking gun, I felt, in this case. But there was enough there that I could not separate it out. I tried so hard through my analysis. I struggled with that. And, like I said, to me, it was just on the line. And I don't know if I answered your question. Did I? Am I?
Good job. Thank you.
Okay, sorry. Are there
Any
any
other,
other?
yeah,
Sorry.
any other commissioner questions for the investigator? Commissioner O'Brien?
Just to say, welcome, immersion by fire, I think. That's all I'll say.
Thank you, Commissioner Bryan. I appreciate that.
Last chance, other questions for the investigator? Seeing none. Thank you, Heather. Good job. So commissioners, you've heard from respondent, complainant did not appear, and you have heard from the investigator. At this point, we would be looking for a motion or motions. There are two proposed findings. So you could take them separately or together. Oh, Commissioner David, sorry.
Yes,
I was just still talking.
I most definitely want to take them separately because of where I'm going at the moment, subject to comments by my fellow commissioners. I move in regards to one, that there are no reasonable grounds to believe that the respondent retaliated in violation of the Maine Human Rights Act, and that this portion of the complaint should be dismissed.
Second,
So it's been moved and seconded on the first claim in the report, no reasonable grounds on MHRA retaliation. Is there any discussion among commissioners? Seeing none. If you vote yes, you are agreeing that there are no reasonable grounds on the MHRA retaliation claim. Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner O'Brien.
yes.
Okay. Is there another motion? Someone's going to have to make one. Commissioner O'Brien, sorry.
Going out there, but I would move that there are no reasonable grounds to believe that EEMC retaliated for engaging in whistleblower protection. And is that enough?
You can tell me if this is an accurate rephrasing.
Okay,
That there are no reasonable grounds to believe that Northern Lights EMMC retaliated against Dr. Multerer for engaging in whistleblower WPA protected activity, and the complaint should be dismissed in accordance with the MHRA. Is that an accurate rephrasing?
thank you.
Yes.
Second.
So it's been moved and seconded to find no reasonable grounds on the Whistleblower Protection Act claim. Is there any discussion? Commissioner Ashby?
Yes, I'm going to vote in favor of the motion, but before I do want to acknowledge how close this case was. The temporal proximity is, I agree with Attorney Randlett, is only one part of the analysis, but boy, it's a big part. And the decision on the part of respondent to extend the contract in July, and then we ran through that schedule, that series of events, but then to hear from her that she was complaining about these problems, and then to have her complain for 3 days in a row via email, and then on that fourth day, that was the decision apparently to terminate her. That really does go not just to the temporal proximity argument, but to the pretextual argument. And I think the analysis comes down to whether or not this person was a problematic employee generally, or were they a problematic employee because they had this drumbeat of complaints that may or may not have been valid. And it is really a close call. But I'm going to vote in favor of the motion.
Commissioner David?
Yeah, thank you, Commissioner Ashby. And I think we all agree it's a close call. And thank you, Heather, for this baptism by fire. But I am going to vote favor of the motion also. She's a locums. The extension of the contract is because they're desperate. They're desperate because of a chaotic situation. A really chaotic situation with somebody leaving, with a desperate need to try to service patients, with crew with support professionals needing retraining because of the combinations of a new practice. What they needed was somebody to come in that positively could instill confidence and leadership and lead them through that difficult time. A month in, she's told your behavior is disruptive and toxic, and you're not going to have a permanent job unless that changes. And then she starts to angle for evidence that she never gets. So I'm going to vote in favor of the motion.
Any other discussion among commissioners? Seeing none, the motion is to find no reasonable grounds on the Whistleblower Protection Act claim. If you say yes, you're in agreement. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
So the finding is no reasonable grounds on both claims. The commission will send the parties and council a letter confirming that, and we thank you for being present.
Great. Thank you, Attorney Randlett. All right, the next case is E200410 Cole versus Russell. That is a reasonable let's try again. A reasonable grounds case. So as a result, we should hear from the respondent. Is the respondent here or a representative of the respondent?
Charles Russell here.
Great, Mr. Russell, you have 10 minutes.
All right. I guess my first, I have a question. I thought that there could not be sexual harassment or discrimination in the workplace among elected officials due to Maine case law, and I think I noted that in my submission to the investigator.
So this is not actually a question and answer period from the commissioners to answer your questions. So this is your time to just present.
Okay. All right. So I'll present that as I can't find where it is before, but it was included in my submission. And I think as an investigator ruled, there was no evidence or anything of sexual harassment. I never sexually harassed Ms. Cole at any time. Now, there is a finding of retaliation for posting one of her submissions. And it's more of trying to clear my name. Ms. Cole shared information with the Karen Garish, who is a long...
No other names. I'm sorry, Mr. Russell, you
Okay.
cannot use the names of anyone who's not a named party to this
Okay.
case.
Okay, sorry about that. I'll make sure I don't do that. So Ms. Cole attempted to have me recalled along with a relative of hers and his longtime live-in girlfriend. During the recall procedure where her cousin's longtime, basically wife, was the lead participant, she brought up the sexual harassment charges that were pending against me with the Human Rights Commission. One of Ms. Cole's ex-boyfriends, who she remains friends with, physically threatened me on Facebook for sexually harassing women. Another one of Ms. Cole's friends came into town meeting and said that I had been accused of sexually harassing Ms. Cole. So my point is that during several recall elections, these things were brought up to derail my campaign. And I felt the need to put that out there because Ms. Cole had already spread this everywhere and people needed to understand both sides. As you guys know, if you say something enough about someone, it sticks. You know, my wife had to worry about someone coming to the house after the threats on Facebook. My kids were getting harassed because their father sexually harassed someone. This was used as a weapon. And I think if the commission,
I'm sorry, Mr. Russell, that is not in the record, so it
what's not-
cannot be discussed at this time.
what part of that?
Um,
I'm sorry, it's my first time. I don't. What?
Sure.
If I can just interject, so I don't believe there's anything in the record where you stated, Mr. Russell, the results of any, discussions that Ms. Cole may have had. So anything about that.
Any impact on your children or your family?
Okay.
That was
well,
not previously provided to the investigator.
I
so it
didn't.
wasn't part
I
of the
didn't
investigation.
know. But I
Mr.
didn't.
Russell, this is not the time to discuss what you knew during the investigation. I'm just being clear about what you're allowed to discuss now.
I didn't know there was an investigation about the retaliatory because my email had gotten
Mr.
taken
Russell?
away. So
Mr.
that's the
Russell,
explanation. All right.
I'm
that's fine.
sorry.
No, I understand. I'm just trying to get the feeling for the rules. All right. Well, the reason that it was put out there was to clear my name. Obviously, I would not put something out there about me being charged with sexual harassment if it already wasn't everywhere due to it being spread around. And again, I don't think that there was any jurisdiction to even have this, is my understanding, have this original hearing, which I put in my original information. And there was not any proof that, or any one time that I ever sexually harassed Ms. Cole. So that's what I have, I guess. I didn't understand fully the rules of the hearing, and I apologize.
Okay, just a second. Any commissioner questions for Mr. Russell at this time? Mr. Russell, just so you know, you'll have just over 6 minutes when we come back to you.
Okay.
So at this point, we would turn to Ms. Cole, which, Jeff, I just realized that in the last case, I asked you to do that, and now I'm doing it.
From now on, I deputize you.
Okay,
if
great.
need be.
Got it. So Ms. Cole, you have 10 minutes. And again, please do not use the names of people who are not parties to this case.
Okay. Good morning, commissioners. Having taken the required sexual harassment class for supervisors, I find it difficult to believe that the treatment I endured, such as the uncomfortable leering, inappropriate comments, especially in front of leaders of abutting towns, and accusations of sexual misconduct did not rise to the level of sexual harassment or at least an abusive work environment. Mr. Russell's behavior just got worse until I was forced by a late night call when he accused me of, quote, fucking my cousin. It was then I reported it to our town's human resource officer the very next morning. Then I brought it forward in an executive session. This is a statement I read to the selectmen. Statement that I delivered to the Board of Selectmen on August 13th, 2020. Fellow selectmen, I would like to discuss the conduct and increasingly inappropriate behavior of Chairman Chuck Russell towards me and his growing disrespect for me as an equal selectman of the town of Lebanon. When we were first elected, Mr. Russell invited me to his home for a cookout to meet his family and others. A gentleman who had a judgment against him with and I am not using names that I originally used in the statement. A gentleman who had a judgment against him with a $20,000 fine that Mr. Russell later wanted us to forgive as selectmen. 2 other guests that are now members of the appeals board. He also made mention that another selectman and his wife were expected. That would make a quorum. We had discussed the issue when we had met at a local bar and restaurant once before, and I was not comfortable with the 3 of us being anywhere together as could be considered a meeting. It made me very uncomfortable that he invited these particular guests. I left before the other selectmen showed up and I never went back. Not long after that, he said to me right before a selectmen's meeting, quote, "Wow, you look beautiful tonight," end quote. It made me very uncomfortable. I did not respond. Since then, I had tried to get to meetings early to put a chair between us. Mr. Russell, since then, has consistently belittled, humiliated, and made uncomfortable comments and harassed me in public proceedings, town-related site visits, and over the telephone. Below, I have listed just a few examples of this behavior. One, most of the time, when I bring an idea to the table, Mr. Russell will look at me with disgust and or laughs at me. This can be seen on many Board of Selectmen videos. On February 20th, when the board was going into an executive session regarding a fire department issue, Mr. Russell forced me out of the meeting saying it was a conflict of interest because my daughter is an EMT with the department and asked me to leave, having previously gained the support of the other selectmen to remove me. I consulted with my lawyer the next day and he had no right to do that as we were equals. Maine's Title 30A subsection 2605 conflicts of interest, number 4 clearly explains financial interest. When our children were young, my late husband and I developed house rules for them. One of them being that if they were students, they would not have to pay rent. My daughter is working on a double major at the moment, and I'm keeping my word to her, and she does not pay me anything to live at home. On January 9th, 2020, in front of 2 attorneys, Mr. Russell twice denied me to speak at a Board of Selectmen's meeting, silencing me. On July 29th, 2020, I arranged for a late afternoon tour of Milton, New Hampshire's new fire station because our fire stations are in disrepair. So anyway, Mr. Russell arrived barefooted and looking like he had just rolled out of bed. He proceeded to tour the station with no shoes on, and every chance he got, he was putting down our fire department and personnel. It was bizarre and unprofessional as a representative of the town. While we were speaking with the fire chief and watching one of Milton's employees in the back of an ambulance, the chief commented on how fortunate they were to have that dedicated employee. I made a comment joking, quote, "I have to get his number. We could use more employees like that," end quote. Everyone knew my intent. Lebanon needs more fire and EMS staff. The chief stated something to the effect he's pretty busy. Then Mr. Russell turned to the chief and told him, "Oh, she only wants his number for personal reasons," end quote, and laughed. It was humiliating, degrading, and I was very embarrassed. On August 6th, the Board of Selectmen's meeting, a resident who happens to be my cousin, came into the meeting with a stack of paperwork that he had obtained via FOIA request regarding Mr. Russell's ongoing case with code enforcement. After reviewing 5 years of violations and reviewing the court judgment, we came up with a short list of loose ends that needed to be tied up. Mr. Russell had to come up with a copy of the paid fine, a copy of his dock permit, and a site visit from our code enforcement officer. The following day, August 7th, I went to the town office to inquire when the code enforcement officer would be doing a follow-up inspection of Mr. Russell's property. I wanted to attend just to make sure everything was looked at and to assure my cousin that the inspection was thorough. It was then the discussion of a third-party inspection was brought up. I thought it was a good idea and got a printout of all the third-party inspectors in York County to bring to the Board of Selectmen the following week. That same evening on Friday, August 7th at 8:45, I received a phone call from Chairman Russell.
No names, please. Ms. Cole, no names. Oh, I'm sorry. That's the respondent. My apologies. Sorry.
He was quite upset that I had inquired about attending the site visit. When I said perhaps we should hire a third-party inspector, he asked if I had been talking to the resident, saying he knew we were cousins. I told him not to make assumptions. Shockingly, Mr. Russell said, quote, "You're probably fucking Chris now. Good night." And he hung up. I was shocked at the accusation of an incestuous relationship with my cousin. I was home alone at the time. Again, it's quarter of 9 on a Friday night at the time, and scared Mr. Russell was going to come to my home as he was so angry. I really didn't know what to do. I bring these issues before the board tonight as I'm no longer willing to tolerate this kind of demeaning, humiliating, insulting, and insult and sexual harassment. Over the course of the past year, Mr. Russell has displayed numerous inappropriate actions for an elected official. Therefore, I am requesting that Mr. Russell resign effective immediately. And that was my statement to the selectmen. After the report to HR, it is the real hostility escalated, as I have stated. I was silenced at more than one meeting and continually treated badly at Board of Selectmen meetings by Mr. Russell and his friends. Many of these incidents happened during televised meetings. I was also denied equipment and resources to do my job as a select person, such as a phone and a laptop, which many other department heads have, and accessibility to the town attorney. Mr. Russell used his position as chair to filter information that was important to the town from myself and other selectmen, leaving us in the dark on many issues. And regarding Mr. Russell's 2 recalls, the first recall had nothing to do with me, but a former select woman and beloved teacher for the nasty things that Mr. Russell said about her in social media, about her personal relationships. The second time was not initiated by me either. It was about alleged theft of award-winning cannabis from a resident that was in custody due to a domestic dispute, an incident that was covered by the Boston Globe and other large newspapers and media outlets. It was right before his second recall that Mr. Russell tried to use my statements to the Maine Human Rights Commission to smear my name. Again, posting on social media, not only on his own page, but shared to a local page, the Lebanon, Maine Truth Seekers, run by one of his friends that has over 6,000 subscribers. I love my community and only wanted what was best for it. I ended up living a nightmare, having to work with Mr. Russell and his many nasty friends that he allowed to continually attack me during weekly Board of Selectmen meetings. Thank you.
Thank you. Commissioner questions for Ms. Cole? Not seeing any. And before we return to Mr. Russell, I want to point out, as Barbara noted, that we actually should not have started with Mr. Russell because he did not submit any objection to the recommended reasonable grounds finding. The only submission we received was from Ms. Cole objecting to the no reasonable grounds proposed finding on the sexual harassment claim. So
forgive me,
I apologize.
This is uniquely postured. I apologize. I did see
It is.
the complainant was the only one to respond.
Yeah, and I didn't think about that at the time either. So so I just wanted to point that out before we return to Mr. Russell. Mr. Russell, you have just over 6 minutes left. If you want to use them, you don't have to. You are muted if you do want to use them.
Yes, so I can respond to what she said there in my time. Is that correct?
Yes.
Okay, so in her opening statement, she calls me a supervisor, and then she goes on to say we were equals, which we were equals. I was chairman. She made several attempts to become chairman. After she was not voted in to be chairman, is when she submitted the sexual harassment charge. She stated, she quoted me as saying, I said she looked beautiful before a meeting. That is not true whatsoever. I said she looked very nice when we were walking in. That's not sexual harassment. She talked about the equipment that she asked for that we didn't give her. She wanted a phone. No selectman had a phone. We were on a limited budget. She also wanted a laptop. The only selectmen that got laptop were the chairman and the vice chairman. She wanted access to the town attorney. Town attorney charges about $200 and some an hour. It's a standard procedure that the chairman and the vice chairman are the only ones with access to the town attorney. She talked about a statement she said I made of accusing her of fucking her cousin. That's not what I said. I said you and your fucking cousin. Because I was upset. She was trying to use his approach to come to my property to get me out so she could be chairman. She talked about being mistreated at meetings. All those meetings are on video, and I assume the investigator watched them because I did not mistreat her at meetings. She talked about being silenced when attorneys were there. She didn't mention they were opposing counsel that were threatening to sue the town and Ms. Cole was about to mention things that could have put the town in a bad position legally and given them ammunition for their pending lawsuit. As chairman, it's my job to control the meetings and make sure people don't say things that they're not supposed to say that would open the town up to litigation. She talked about the comment that I made at the other town's fire department.
Mr. Russell, I want to just mention that a lot of those details were not in the record. There was more discussed in Ms. Cole's presentation than was in the record. So I would ask you, if assuming that you are familiar with what's in the record, to not go beyond what the investigator had a chance to consider. Sorry, go ahead. Sorry for the interruption.
Okay, I don't have what's on the record in front of me. But again, that simply wasn't true. And she named the chief by name, and I assume she could have gotten something written by him saying that I said that, and that just simply was not true. Let's see. Yeah, and again, she mentioned the posting that I made of her complaint. And yes, I did make that. It was not retaliatory, but it's not fair to have just one side of the story out there that was told to so many people in our town. So I felt the need to get my side of the story out there and not just be labeled as a sexual harasser. It wasn't retaliatory. If everything had been confidential and nobody had known about this, why on God's earth would I want people to know I was accused of sexual harassment? I wouldn't. And I think people understand that they wouldn't either. So as for not being allowed to speak or being asked to remove herself from the fire chief's and the fire department's hearing, yes, that's fact. And that's because her daughter lives with her, like she stated. And that, according to our town attorney, creates a conflict of interest because of shared costs at the home. Regardless of what she says, whether they do or don't, it still could be brought up and open the town to litigation again from the fire chief, who the discussion was about termination. And her daughter led the charge of the local members of the department to have him removed. So there were tough decisions that I had to make as chairman with Ms. Cole and not allowing her to say things and not allowing her to have certain things, but it may have hurt her feelings. But again, there was no sexual harassment there. All of our meetings are on video, and I'm very confident that I treated her very fairly. I had to be firm at certain times, yes, but that was because the people of this town elected me to keep to do things right. So I guess that's all I have.
Thank you. Any commissioner questions for Mr. Russell? Seeing none. Oh, sorry, Commissioner David.
Thank you, Amy. Mr. Russell, what you posted was her complaint to the Maine Human Rights Commission, and you posted that on Facebook, right?
Correct.
And you now understand that that's a violation of a statute, right?
I did not know that, no.
Yeah, you didn't know it, but you know it now. Is that correct?
Well, yes, I understand it now. Yes.
All right.
Thanks to you telling me. I did not know that, though.
Thank you.
Any other commissioner questions for Mr. Russell? Seeing none. Ms. Cole, you have about 15 seconds left if you want to use them. You don't have to. Nope. Okay. So then we would turn to the investigator. Alex.
Morning, commissioners, Amy, Barbara. So this case was pretty simple, like Amy stated. So there was no submission of disagreement for the retaliation claim. So focusing entirely on the sexual harassment claim, the complainant wants to reverse that. However, there was nothing in the record that indicated that the complainant reported to the respondent that these comments were unwelcome. And furthermore, the respondent denied engaging in this conduct, which he repeated this morning during his presentation. So that fails there. But I think that's all, and I'm open to any questions you may have.
Commissioner questions, Commissioner David.
Alex, did you have a chance to watch some of the selectmen's meetings?
I watched all of them. Yes, they were many hours long and it took a long time, but I sure did it.
Put in for overtime.
Nope, she cannot.
I can't do that.
Nope.
That's all.
Thank you.
Any other commissioner questions for the investigator? Seeing, oh, Commissioner Ashby.
Questions. The suggestion, well, can you help me understand, maybe Barbara can weigh in on this. Can you help me understand the level of complaint required by a person who believes they're subject to hostile environment, sexual harassment? What level of objection to the objectionable statements is required to be made by the complainant to the respondent? Because certainly the record is clear that this complainant complained about statements such as the one involving the cousin or whatever. My understanding, maybe I'm mistaken, maybe I don't understand the investigation report enough, but she made a complaint to the HR person at the town. Wouldn't that, if we believe that created a hostile environment, I'm not sure I'm there. I mean, I don't know if I'm there yet. But if we believe that, wouldn't that be enough? I don't know that you're required, are you, to make a complaint directly to the respondent that that's unwelcome? I mean, as I understand it, if we believe the complainant, the statement was made and then the respondent hung the phone up.
Well, there are specific instances where complainants don't have to inform the respondent that their comments are unwelcome, but they're very limited. So, for example, say that the respondent in question is their supervisor or their landlord or has like some power over them that may affect their employment or their housing, then they wouldn't have to report to them. But in this case, they were equals. They were both elected officials, and it didn't seem to me in the record that the complainant told the respondent that his comments that he made to her were unwelcome. And certainly she did inform HR, and HR acted appropriately and scheduled sexual harassment training, but there was no indication that the complainant told the respondent directly.
Ms. Cole, we are not taking any comments from you at this time. Sorry, go ahead, Barbara.
That's okay, Jeff, just following up on what Alex is saying. Reporting to HR would absolutely be enough if this was a claim against the town, but it is not. So we don't know, well, Alex knows, I don't remember from the record what HR did in response, but we don't know if they informed Mr. Russell and told him to change his behavior. We just don't know what happened with that. But because the report was to the town and the town is not a respondent, what Ms. Cole needs to show is that Mr. Russell knew that Ms. Cole objected.
That's helpful. That actually clears it up for me. I was really wrestling with that, but I had neglected to remember that the town's not a respondent.
Yeah, I understand completely, because your question, you're absolutely correct about the standard if this was a claim against the town.
All right, that's really helpful. Thank you. I had one other question, I think, Investigator Brindley. The Investigator David suggested it, but I want to know if it's true or if it's the case. Was it actual submissions to the Human Rights Commission that were actually posted on social media? It wasn't just a discussion of what was happening before the Human Rights Commission, but actually materials provided by the complainant to the Human Rights Commission that then got posted by the respondent on social media. Is that correct?
Correct.
And
the respondent took some of the complainant submissions to the commission and posted it on his public Facebook page.
Okay. And I saw your acknowledgement that maybe the statement that goes out that requires folks to understand that this is a confidential process, that perhaps didn't get done in this case. But if I remember correctly, without soliciting a signature that you understand that it's confidential, something printed to get sent to the respondent, correct? That says
Correct.
this is confidential stuff, right?
Correct.
Right.
Yes.
So it's
And in
more
this
than just,
case, yeah.
it's, first of all, it would be enough probably, but it's more than just saying, oh, respondent should know the law. It's actually, we did in fact tell him in writing what the law says about
Correct.
this. Even
I
if we
believe
did,
it's in, yeah, I believe it's in the notification packet that gets sent out to the
Yep.
respondent.
right, that was my memory from having done this work. Okay, good, that's helpful. Thank you very much.
Thank you.
Any other commissioner questions for the investigator? Seeing none. Thank you, Alex.
I have
Thank
one
you.
more question. I'm so
Oh,
sorry.
no, psych.
So-
kidding.
Commissioner Ashby.
Yeah, it's not to Alex, it's to Barbara. So it is an interestingly postured case. Once the complainant makes a complaint about one of the findings that gets us before, or gets the parties before us, is the respondent foreclosed from arguing his finding completely? I mean, what if, maybe it's true. Maybe he did in fact convince us today that that the second of the two findings shouldn't have gone the complainant's way. Are we absolutely, as a matter of law, precluded from deciding differently than how the investigator found?
No, you could reject the investigator's finding all on your own for any reason or no reason, as long as it's not an illegal reason. But I mean, in general, our procedures are you don't get to appear before the commission except to rebut the other side unless you submit a statement of disagreement. So as a formal matter, it was not challenged. That said, if you don't believe the finding is supported, you can reject it.
Okay, that's helpful also. Thank you.
Any other questions for the investigator or counsel? Seeing none. Nope, not you, Ms. Cole. I understand that my question may have been vague, but my question should have been any other commissioner questions for the investigator or counsel. Okay, so then commissioners, we will be looking for a motion or motions. You have two proposed motions before you. Commissioner David?
I'll move to take them together and move that there are no reasonable grounds to believe that respondent discriminated on the basis of sex, and that part of the claim should be dismissed, and that there are reasonable grounds to believe that respondent retaliated in violation of the MHRA protected activity, and conciliation should be attempted.
Is there a second? I am not seeing a second.
I'll
Okay.
second.
So it's been moved and seconded. Is there any discussion? Commissioner O'Brien?
You were waiting for me, Jeff. You were waiting for me, but I'm glad you did it. No more discussion.
Commissioner Davis?
I think that was educational, that discussion with counsel about our authority on number two, but it's quite clear to me that given the fact that it's in the materials, that it's not just the technicality that he's charged with knowing what the law is, and that that's a violation. So I'm comfortable with both of them. And also in regards to one, that it's a little, I mean, some of the behavior is obviously inappropriate, but a lot of the behavior was description of political intercourse that they clearly are at odds about, but the resolution for that belongs in the political sphere.
Any other discussion among commissioners? Seeing none. So the motion is to find no reasonable grounds on the sex discrimination claim and reasonable grounds on the MHRA retaliation claim. If you say yes, you are in agreement with both findings. Commissioner Ashby? Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Okay, so both of those are adopted. And the commission will send the parties a letter confirming that and letting you know about next steps on the reasonable grounds finding. Thank you both for being present. I do see Dr. Multerer has joined us. And Dr. Multerer, the case that you're involved in was already heard and decided. The commission will send oh, nope, did she go away?
I'm here.
Oh, there she is. Okay. Yeah, we heard the case as planned. And everyone was directed to be on the call as of 8:45. So the case was already heard.
Do you know what? If the time zone is off.
I can't be responsible for everybody's time zone.
Yeah,
I'm sorry.
I apologize for that.
Yes.
So how was it decided?
You can check our minutes, and also the video is available on our website. So we will send a letter.
That was my error because I was on Eastern time zone. I logged on at Eastern time zone. So I'm on Central time zone and I logged on at Central time zone. So that is my misunderstanding then.
So we will send a letter.
All right.
Thank you very much.
Thank you. Bye-bye.
Bye-bye.
That is E200443, Benoit versus Hannaford. That is a.
Oh, nope, we skipped one.
Oh, I'm sorry.
There's one before that.
I thought I was doing so well.
You are doing spectacularly. You're doing great.
No, that's a stumble. All right, forgive me. Our next
Don't be so
case-
hard on yourself, man.
Our next case is E200437. And forgive me, is it DJAC versus State of Maine Department of Labor, Bureau of Labor Standards? That is a no reasonable grounds case. And as a result, we should be hearing from the complainant or the complainant's representative.
Good morning. My name is Taras Diak. I'm the complainant.
Thank you, Mr. D.
Good morning,
Is
Mr.
it so
Diak.
Diak?
Yes,
Okay,
Right.
Diak or Diak. Probably going to get it wrong
that's fine.
again. So you have 10 minutes, and I'll just remind you not to use the names of anyone who's not a party in this case.
That's fine. So this case involves my dispute with the Department of Labor in enforcing the OSHA regulations for first responders. In this case was the September 16th event surrounding Farmington's propane gas explosion, where Captain Bell died at that facility, that scene.
I'm going
And
to remind you not to use the names of any people who are not parties to the case, which you just did.
My apologies. So it's a very well-known case in Farmington where I was the investigator for that case for the Department of Labor. As you know, if you've read through the report, and I don't want to rehash it, it's still a pending problem that there is no enforcement from the Maine Department of Labor when they do inspections of fire departments. So I'll leave it at that. I don't agree with how I was portrayed in this inspection, that I accosted a federal official. So I request that to be removed from the investigator's report. I approached a federal official to make valid complaints. I did it in private because I was being told by my bosses to not talk to anybody about this. I think seriously, they were embarrassed that they weren't doing what they should have been doing, and me bringing this to light showed their deficiencies. And I understand further that this case would be dismissed, but I feel I did not have due process in the whistleblower investigation. My direct bosses were the whistleblower investigators for the state of Maine. When I brought these things to their attention, they made motions to try to correct. They still haven't brought it to the level that it needs to. It needs to go to the Board of Occupational Safety and Health and to have these things corrected. not only here at the state, but other federal levels, where no states are doing enforcement of this federal regulation. And so I'll leave it at that.
Okay, thank you. Let me just make a note. Any commissioner questions for Mr. Diak at this time? I probably just pronounced it wrong again. Sorry, I'm going to do that a few more times. Any commissioner questions for complainant at this time? See you, Commissioner David.
Mr. Diak, the retaliation that you claim was the write-up and the counseling that was ordered. Is that right?
It was more than just that write-up. I was silenced throughout the whole process. I was told not to talk to other investigators. It was not a coordinated, it seemed like a coordinated attack against me to keep silent. And so this continued for many years. And I was trying to work in conjunction with my supervisors to try to correct this, but
was there any other disciplinary action taken against you?
As far as being kind of outed as like a troublemaker, which I'm not, I'm trying to make the correct decisions going forward and do the correct things to have this not occur again. And in those cases, I was basically just told you can't talk to anybody, and felt to be like an outsider, and silenced in my efforts.
Thank you.
Any other, Commissioner Ashby?
Read your submission in opposition to the investigator's report, and you indicate that in fact the respondent did find merit in your complaint, you say, up to the point there was a BOSH board meeting. What's a BOSH board meeting? What's BOSH?
The Board of Occupational Safety and Health.
So it's my understanding that your complaint is that, well, your complaint acknowledges that they did in fact take you seriously, listen to you, and then apparently undertake some sort. Was that the appropriate thing for them to have done? Would a BOSH meeting have been the right thing for them to have done?
I think they didn't let me speak at the BOSH board. I would have handled it different and tried to explain that there was a specific requirement to do the inspections for fire departments, which we weren't doing. We didn't do the inspections per the federal requirements, because the OSHA standards are basically industry-based, and they try to adopt them to public sector, and they get confused with that things, and they still have some unclarity there on how first responders react for hazmat situations. So the BOSH board did make some changes. And as I pointed out to the investigators report, basically they just copied some documents from other states, yet they left out some of the most important things you would do as an inspector. And they basically look at only the training requirement for hazard, which is incident command systems. And they basically accept that you can look at a DOT book for hazardous materials, and that's adequate training. And my stipulation was the federal requirements for doing an inspection in this area requires you to examine the procedures that any responding agency would look at. If we would look at the agency correctly, the procedures they use, in which we never look at that. I was told continuously through my work as an inspector that we do it our way. We don't follow the federal rules, and I was against that. I said the federal rules are correct. You need to inspect the procedures that are used, not just the training. And the Bosch board did do something to understand that problem, but it wasn't very clear. And I don't think the Bosch board understood that, and has never understood that the federal requirements are a little different than what we adopted here at the state.
Great, thank you.
Any other commissioner questions for complainant? Seeing none, thank you. Mr. Diak, you'll have just about 7 minutes when we come back to you. If you want to use them, you don't have to. And then we would turn to respondent, and I believe that's Jeremy Carter.
Yes, good morning. My name is Jeremy Carter, Assistant Attorney General representing the Maine Department of Labor, Bureau of Labor Standards. The department respectfully requests that the commission adopt the investigator's finding of no reasonable grounds in this case. As the investigator report rightfully describes, in order for a complainant to show that he was discriminated against on the basis of a protected activity under the WPA, he must show that he engaged in statutorily defined protected activity, that he suffered some form of adverse employment action, and that there is a causal link between those two things, even if that protected activity was not the sole reason for the adverse action. As the investigator rightly found, complainant fails to satisfy the third element of this claim, the causal link element. And for the purposes of my presentation this morning, I'll limit my focus to that because that's what the investigator focused on. But if any commissioner has any questions about anything else, I would certainly be happy to take those. A brief overview of the relevant facts. Complainant is a long-serving employee of the Department of Labor. In October of 2019, he was working as an occupational health specialist within the department's Bureau of Labor Standards. It was around this time in early October 2019 that complainant raised his concerns with his supervisors that the state was not in compliance with federal OSHA regulations that related to fire departments and the keeping and maintaining of certain records having to do with hazardous materials contained within a certain town or jurisdiction. Complainant's supervisors disagreed with his interpretation, but they discussed it with him at length, and they promised to investigate the matter further, which they did. In December of 2019, a federal OSHA team was in Maine to conduct an annual state plan audit. Prior to the team's arrival, Mr. Diak was instructed by his supervisors to leave the audit team to its work and not interfere with them unless they specifically requested something from him. Ignoring this warning, complainant was somehow able to discover at which hotel the lead federal auditor was staying and intercept her while she was eating her breakfast in the lobby to discuss his aforementioned concerns. Now, this was plainly inappropriate conduct, not just because it violated an express instruction from his supervisors, but because it broke with the chain of command and exceeded the scope of Mr. Diak's job responsibilities. The federal auditor, for her part, after refusing to discuss the issue with Mr. Diak, immediately contacted Mr. Diak's supervisors to inform him of the incident. And as a result, on December 5th, for this reason and this reason alone, complainant received written counseling. The counseling described his inappropriate conduct. It outlined times in the past when complainant had similarly engaged in such conduct outside the chain of command, and it cautioned him not to do something like this again in the future. He was not in that written counseling or in the meeting ever chided about raising the concerns that he did with his supervisors. He'd been raising those concerns since October of 2019 without facing any disciplinary actions. He continued to raise those concerns well into 2020 without further disciplinary actions. In fact, in the very meeting in which the counseling was issued, he was permitted to talk at length with his supervisors about those concerns. And he later in an email thanked them for that opportunity and said he felt much better as a result of having that conversation. The only time he was ever cautioned about his conduct was when he disobeyed the express instruction from his supervisors, stepped outside the scope of his duties, and visited that hotel. Further, as the investigator noted in the report, complainant admitted in the Issues and Resolutions Conference that he believed, even he believed, the reason for his written counseling was because of his visit to that hotel and not for any other reason that he stated. So for these reasons, complainant fails to make any showing that his written counseling was as a result of anything other than his inappropriate conduct with the OSHA auditor in violation of his supervisor's instructions, and he fails to demonstrate a causal link for the purposes of the WPA. The department respectfully requests, that the commission adopt the investigator's reported finding of no reasonable grounds, and I'm happy to take any questions. Thank you.
Thank you. Any commissioner questions for Mr. Carter? I see both Commissioner Ashby and Commissioner David. Commissioner Ashby?
How do we distinguish between the case where the person breaks the chain of command and he's a hero for saving the world, and the fellow who breaks with a chain of command and irritates his employers about something that's sort of boring and mundane and maybe he's wrong about? Now, I know those aren't necessarily the facts in this case, but my question, I guess, isn't going to find the federal investigator at her hotel the purest form of whistleblowing?
Not under the Maine Whistleblower Protection Act. The Maine Whistleblower Protection Act is pretty clear and has been interpreted by the law court as a public body reporting to a public body means a state body. In the definitions of public body within the statute, it doesn't list federal agencies, and the law court has similarly found that. Further, even if it was an appropriate conversation to him, we're not objecting to what he said to her. The objection is the manner in which he said it, how he arrived there. She was an out-of-town visitor. She's not from Maine. This was essentially, for the extent of her stay here, this was her residence. And he showed up there uninvited, off work hours, in the lobby where she was eating breakfast. So even if we were to say that what he was doing was protected activity under the Maine Whistleblower Protection Act, which we don't, because she was a federal agent. Again, it's the problem here is the manner in which he addressed her and confronted her, not the substance of what was said to her.
Let me try to phrase it a little more artfully. I appreciate that explanation, but do you think the level of emergency dictates the reason or is relevant maybe? Do you think the level of the emergency is relevant to the reasonableness of the employee's behavior?
I apologize, Commissioner. I'm having trouble following it. If he was engaged in reporting to an appropriate person, and he was engaged in the protected activity, if it was within the state agency, as the investigator determined that it was a protected activity by reporting it to his supervisors, if that was what was happening, then there wouldn't be a problem of discipline per se, because he was operating within the protections of the Whistleblower Protection Act for Maine. This was a separate situation. And again, it had to do with the manner in which he approached her. So I apologize if that's not clear. I'm not sure I'm understanding your question.
No, the apology is mine. I may not be explaining myself. First of all, I'm not sure I subscribe to the principle that you can't complain to the federal oversight body, the very folks that are there to provide oversight to your state agency. I'm not sure I subscribe that a complaint to those individuals doesn't qualify as protected activity under the WPA. And so let's make the assumption that it does, that you can in fact complain to a federal oversight body and you have the right to do so and you're protected to do so. Then the question becomes, you agree or you're arguing that it's unreasonable that the complaint was made at this person's hotel room. But my question to you is, and maybe it requires a hypothetical. This fellow certainly believed that his employers weren't hearing him, that he wasn't getting through the regular so-called chain of command, he wasn't getting satisfaction on what he perceived to be an emergency. And so he did what he did. I'm making some assumptions, but that's how I interpret the case. And my question to you is, if it had been a big enough emergency, is it ever okay to go to the hotel room and find the person and tell them? And that leads me to repeat my question now. Is the level of emergency, the emergent nature of the complaint, somehow relevant to the reasonableness of the behavior of the person making the complaint?
I don't think the law or the precedent makes that distinction about the level of the emergency here. But again, even if we are arguendo to say that reporting to the OSHA agent at her hotel when she was off the clock, that was covered by protected activity, it was again the manner in which it was done. And further, the investigator later, or the auditor later, contacted his supervisors to express that she wasn't particularly pleased with this either. It had made her uncomfortable.
Right.
So when you add that on top of everything else, the nature in which we're not sure how he found out where she was staying, how that was communicated to him. He went through all these extra steps after being told to run his complaints or any issues he had with the auditor through the appropriate channels in his department. When you add all of these things up, I'm not sure that there's a distinction that can be made by the statute and precedent based on the severity of the believed or purported emergency. But again, this was counseling having to do with conduct, the way it was handled, the manner in which it was brought to the attention of any individual. That was the source of the substance of the counseling.
Great, thank you. This is helpful.
Commissioner David?
I'm sympathetic, Jeff, to your situation. I think obviously there would be situations in which there was a genuine emergency and public safety was at stake, and you blow the whistle to whoever you can, wherever you can, including their hotel room. But that's but I'm not uncomfortable with looking at what he was trying to go around the chain of command to get to the auditor's attention, which is his complaint that the regulation about knowing where hazardous materials are is not being followed. My question, Attorney Carter, is he still employed?
I believe he is, yes.
Does the record indicate whether there's any further discipline?
The record for this case, when it was closed, there was no further discipline, no. And not relating to this, no.
Okay, thank you.
And I'm sorry, if I could just say,
yeah.
I should have said to Commissioner Ashby that this was not a situation wherein he had to go to somewhere else because his supervisors had shut him down. As I said, they were taking him very seriously. They were referring this to internal committees for further discussion. They disagreed with his interpretation, but they respected Mr. Diock. They took his opinion seriously, and they were looking into it. So it's not as if he had all other channels exhausted. They were engaged with him in a discussion on this.
Thank you.
Thank you. So any other commissioner questions for Mr. Carter at this time? Okay, so Mr. Carter, you'll have about just over 5 minutes left when we come back to you. And now we'll go back to Mr. Diock. Mr. Diock, you have about 7 minutes. You can use them, you don't have to. Oh, okay, great.
Yes, I am, just to correct the record, I am retired. So I am not currently employed with the Maine Department of Labor, partially because of this ongoing problem.
We only, I'm going to ask you to keep your comments to only things that are in the record. Thank you.
Okay. This was a quite a significant case, and there are still unresolved issues, which one of the reasons why I went to the federal investigators, they gave out the cards where they were staying. So during the meeting, they had their hotel cards there or something to that effect. So where I knew where they were staying. I approached the federal investigator team, not specifically the person that was accusing me of, well, I guess the attorney put it down, or the investigator wrote it down that I accosted the federal official. I was there in good faith to try to find out what could be done to remedy the situation. And at that point, I was putting my career on the line. I was doing this in good faith, and the hazmat system is still a problem in the state. So the safety data sheets, as I wrote to the investigator, if you look at the safety data sheet for that incident, it's still revised, I think, to only 2012. So it has outdated information about the health hazards of being exposed to high levels of carbon, of propane. Propane's mixed with butane and other chemicals in the system. All those things have properties of anesthetic nature, and as part of the investigators team, we knew that people were having some problems there during that event, reporting headaches and dizziness. So I tried to remedy that situation by approaching the team because I thought there needed to be a hazard alert sent out for propane and its exposure when you're in high levels of it. There's been many events where people are in tank gauging activities and they have high levels of exposure to these chemicals and they can pass out. But also they are cardiac sensitizers and cause sudden death. These are not in the current safety data sheets that are for that company. So if you go to look for that company, ask for their safety data sheet. It's still outdated information. And when I brought this to the attention to the fire marshal, they were quite shocked that they weren't ever trained in the anesthetic effects and cardiac sensitization effects of propane on the human body. I also, although I wasn't written up for it, I wrote to the coroner's office as soon as I found out that in early October, that should have been part of the case inspection. The coroner's office wrote back to me, thanking me and asking if there's anything more we could do. And I was told, don't respond back to them, don't talk to them. Those are the kind of ways I was treated in this inspection. I was basically taken off that inspection. I couldn't talk to the other federal OSHA, local folk OSHA inspector about that. I had some questions. And basically that's how I was dismissed. You're off the case. We're going to take care of it. We're going to write a citation how we want. And I said, you need to write the citation this way. And I was, it was rejected. And there's a mischaracterization of what I wanted to have done. It's not that I wanted all towns to know where their hazmat materials are. It's that I wanted us as the inspecting bodies to inspect for the proper plans for emergency situations. Okay, I'm done at this point.
Okay, thank you. Any other commissioner questions for Mr. Diak? Commissioner O'Brien?
Yes, I guess. And I'm really not sure how to.
I thought so.
Word it. I don't know where that came. First of all, I think we all appreciate your knowledge and your expertise and your efforts to prevent another tragedy. In hindsight, and you just talked about two things. You said you wrote to the coroner or were in touch with the coroner and you weren't written up about that. So in hindsight, I think it was you who mentioned the term accosted, referencing that it was in our I think it was actually you mentioned it, and I think it was that term came from the respondent, not sure, but in hindsight, is it, do you think you would have or could have done it differently than going to her hotel? Not so much, I see it as not so much a chain of command issue, but again, the manner you did it, do you believe now in hindsight that you could have done that differently?
I'm sorry, the investigator is noting that something is not in the record. I'm not sure precisely what.
That was a past comment that I had made,
Okay.
Amy.
So sorry. Sorry, Commissioner O'Brien. Go ahead, Mr. Diak.
Yes. Hi, Julie. To your question, I could have done it better, but I was away from the interview team the day before. I would have pulled some of the other interview teams that I had connections with, that I've known in the past, and spoken to them on the side, but I was never able to have that conversation at the office. So the investigator team was there the day before. And that would have been, and I attempted to, that's would have been my method, is just to try to find them in the office, talk to them in the hallway, take them aside, and go to the cafeteria or something.
Commissioner O'Brien, you all set? Okay, thank you. Any other commissioner questions for Mr. Diak at this time? Seeing none. Thank you, Mr. Diak. Mr. Carter, you have about 5 minutes left.
Thank you. The department does want to reiterate a comment that Commissioner O'Brien made. We do not at all claim that Mr. Diak was acting in bad faith or that he wasn't totally earnest about his complaints. He's, like I said, he's a long-serving employee. His service, his knowledge, his experience, expertise were all very much respected, which is why his complaints were taken seriously. We do not question the sincerity of that at all. Again, it's why the nature of this counseling was very narrow. It was very limited to expressing the problem with that individual action of going to that hotel room or going to the hotel lobby the way he did. I think he mentioned that he was worried that his career was on the line. That was never the view of the department. This was a very, very minor cautioning. It never elevated to a written warning, a written reprimand. It never went further than that, even as discussions about this issue progressed. So if Mr. Diak felt that his career was on the line, I can assure you that was not the department's view. His career was not in jeopardy as it relates to this. It was, again, like I said at the beginning, it was about that causal link. Did he get the discipline, or did he get the counseling because of what he was saying, because of his reporting? And the answer to that, I think the record makes clear, is no. It was because of his conduct that specific morning in December. Thank you.
Any commissioner questions for Mr. Carter? Seeing none. Thank you, Mr. Carter. So then we would turn to the investigator, Alex.
Hello again, I'm still Alex Brindley. So there are a few things that I want to address. Let me just look at my notes. First, I do want to emphasize that the respondent in this case did address or attempt to address the complainant's concerns. After it was reported to his supervisors, the supervisors did research. I believe one of the supervisors went to a meeting where he discussed the different state plans and Maine's different standards with other people at the same level from a different state. So that was discussed. And essentially, I believe the crux of the matter is Maine has a different OSHA approved state plan than other states. So, but I will state that it's still an OSHA approved plan. And I think in this case, if I'm understanding OSHA correctly and understanding the complainant's claims, I believe the complainant wanted more than just like an awareness only standard, which is what Maine is held to for firefighters based on their OSHA plan. So he wanted more reporting, more, I mean, he stated it previously in his presentation, he wanted the state of Maine to know and like be sure that, be aware of like where all these hazmat things were in different cities. But based on what was provided to me and based on the respondents' research, along with their conversations with other states, I mean, it wasn't necessary to be implemented. I mean, the state plan that Maine has is fine. It's perfectly acceptable. It is one of 6 states that has similar state plans. And I think the crux of the matter is the fact that there is no causal connection between his report and the discipline that he received. I mean, he reported that he believed that the state of Maine was violating federal regulations, which the respondent addressed appropriately by talking to other states, doing more research. And then a couple months later, the respondent found one of the federal auditors at her hotel, which made her uncomfortable and was disciplined accordingly. So I think we're really missing the causal connection there needed for the WPA claim. And I'm open to any questions as well.
Thank you, Alex. Any commissioner questions for the investigator? Seeing none. Thank you, Alex.
Thanks.
So commissioners, we have one proposed finding, so we would be looking for a motion.
I'll move that there are no reason that we find that there's no reasonable grounds to believe that the respondent retaliated against complainant for engaging in WPA activity, and the complaint should be dismissed.
Second.
So it's been moved and seconded. Is there any discussion among commissioners? Commissioner Ashby?
A fascinating case. I think you got it absolutely right, Investigator Brindley. But I can't help but think of the Hollywood version of the Whistleblower Protector, right, or Protection Act, right, where they're the hero for taking extraordinary measures to save mankind or whatever they do. And I have a hard time sometimes distinguishing whether that's this case or whether it requires something different. But I think what's significant in this case, and I think, is that this complainant had his concerns addressed in a way that seems to be what should have occurred. I mean, it seems like he also followed the chain of command, and the chain of command took him to a place where he's not satisfied with the answer. But I think at some point, your dissatisfaction becomes sort of unreasonable. And that's why I think going to the hotel room in this instance, in this case, is unreasonable. Otherwise, I'm not sure that every case where you track down a federal investigator at their hotel room is necessarily a case where not following the chain of command means that you lose if you're a complainant. Because if I'm a respondent in one of these cases, I'm always going to say you didn't follow the chain of command. That's the first defense you raise, right? And you've got to look at that defense with a grain of salt. But in this instance, in this case, I think we have a very committed complainant who knows a great deal, but I interpret him to be simply dissatisfied with the answer, but the answer, I think, is perfectly sound. It requires a lot of careful investigation that I think you did, Investigator Brindley. And so I don't think it's a very close case, but I do think the issues that I raised in my questions are valid questions. I think that there is a time when you can go chase down a federal investigator in their hotel room, just not this case.
I agree.
Any other discussion among commissioners? Seeing none. So the motion is to find no reasonable grounds to believe that unlawful Whistleblower Protection Act retaliation occurred. If you say yes, you're in agreement with that finding. Commissioner Ashby.
You're muted, Jeff.
Yeah, Jeff, you're a little frozen, maybe.
Yeah.
There you are. I see you, but you're not.
Yeah, everybody froze there for me for a second.
Okay. I think your internet is a little spotty at the moment, because I can occasionally see you moving and occasionally hear you.
Yes, again, still.
I hear you now. Can you, so the motion is to find no reasonable
Yes.
grounds. Ah, gotcha. Okay.
Yeah.
Thank you. Moving and talking. Commissioner David,
Yes.
Commissioner O'Brien.
Yes.
So the finding is no reasonable grounds to believe unlawful retaliation occurred. The commission will send the parties and council a letter confirming that, and we thank you for participating today.
I have a question if I could.
Depending on what it is, yep.
My release from my disclosure agreement that I had to sign.
Yes, as the non-disclosure agreement itself says that it's while the case is open. So as soon as we publish the case on a commission agenda, the non-disclosure agreement is no longer an issue. The only things that you cannot discuss are the names of third parties. That remains confidential under the Maine Human Rights Act.
And will the term accosted be removed from the report?
Thank you. Now it seems like my internet connection is unstable. Okay, so I believe that, yep, next.
You can hear me? I'm
yes.
live? All right.
Yes.
Is E20-0443 now Benoit versus Hannaford. This is a no reasonable grounds case, and as a result, we should hear from the complainant. Is the complainant here or a representative?
I don't believe either, but I'm glad you called to ask because I don't see either anyone who's entered an appearance for Mr. Benoit or Mr. Benoit. So typically, when the party who objects to the finding does not appear, typically the commission votes to adopt the recommended determinations.
I'm happy to entertain a motion.
Commissioner David?
Yes, I didn't have any problem with it on its face, and I'm happy to make the motion that we find that there's no reasonable grounds to believe that Hannaford discriminated, and the complaint should be dismissed.
I would second it.
Thank you. So it's been moved and seconded to find no reasonable grounds to believe that Hannaford discriminated against Mr. Benoit on the basis of disability. Is there any discussion among commissioners? Seeing none. So I'm just making sure I don't have any emails indicating that there was trouble getting online. So if you vote, so if you agree with the no reasonable grounds finding, you would vote yes. Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
So
and
I want
to thank Heather. Was an excellent report.
Good job, Heather. And thanks for being here, Mr. Shook. The finding is no reasonable grounds, and we will send a letter reflecting that to parties and council.
Thank you all.
Thanks.
That ends our morning session.
Yep.
And we are required to be back here at 12:30. Is that correct?
We are indeed. And think, just commissioners, just that today is a good opportunity to consider whether we want to keep you doing morning and afternoon sessions or putting all the cases on in the morning, which is inconvenient for the lawyers or parties involved because they have to sit there, but it would let us get to cases that we have now set aside for the afternoon. In the past, you have told me that you prefer doing morning and afternoon, but I just wanted to sort of present it so you can ponder in the future if this is how you want to do it next time, because it's kind of unpredictable. So, so we're off until 12:30. Oh, sorry, Commissioner O'Brien. Sorry.
That's okay. I just wanted to, I sent a note, my sister's in the Senate office, and Barbara was correct. They're having a confirmation session tomorrow. So
thank you.
We should be set.
Thank you. Barbara is usually correct, which I never tell her because she'd get a big head, but she is
true. This is still recording, correct?
This is still recording, yes. So we'll see you all at 12:30. And you can stay on here. You can keep this open or you can come back in. I'm just going to leave it I think it's probably easiest to just leave it running, I guess. Yeah,
Yeah,
guess.
I think you probably ought to leave it running.
yeah, I'll just leave it going and everyone just mute and turn your camera off and we'll see you at 12:30.
I was just trying to look. There's no chance of anybody having shown up that
Nope.
we could move in.
Nope. Nope.
All right, thank you.
We'll see you at 12:30. Thanks.
So Amy, we have a few minutes and it looks like we have everyone here. Are you here, Julie, with us? You're on mute, Amy.
You're muted, Amy.
And I see that Julie's on mute still, but I'm wondering,
Yes.
is she within earshot?
She is, at least her screen is.
No, she must still be away from her desk.
Yeah.
I would take a few minutes before we start the afternoon session to talk about a couple of things. That one is the question you posed at the end of our morning session about dividing the day up. And the second is we should probably have a chat about when we might resume in-person meetings.
I think that we should do that. Yes, I agree. Which I think we can and perhaps should have a sort of, that relates to the commission's rights and duties. I would say that that is something that we could do in executive session if you want commissioners to be able to speak freely.
Right, well, we can pop into executive session at the end, and if we're not too tight for Ed. If we are, well, if we are, we just can't, I guess. So.
And the question of the scheduling, arguably, that is something that we could discuss in executive session as well. We're at a meeting, we're in public. If you guys want to, it's not something that requires a vote.
No, I'd like Julie to be present.
Yeah, no, I agree.
But yeah, I don't care if we're in executive session to discuss that, but we'll see if Julie comes on in the next couple of minutes.
Okay.
If not, we can try that at the end of the day.
Yep.
Thank you.
Thank you. It's helpful to me in knowing what the commissioners, how you want to proceed on handling things.
Historical question, Amy. When we were in session, I only had 2 meetings in 2019 before COVID shut us down. I can't remember. Did we have a morning and afternoon session, or was everybody there? I think everybody was there, weren't they?
Usually, historically, the commission has done it both ways over many, many years. And it's usually a function of how many cases we have. If we have too many cases, typically I have tended to put all the cases on at once. If I think that we could get done by about 2 o'clock, if everybody showed up and all the cases went through to argument, I have tried to push us through. And the reason is because exactly what happened today, which is if people unexpectedly don't show up for the morning, then we're kind of hamstrung and you all have to come back for the afternoon. Whereas if everyone's here, we can slot people in as we see fit. It's more expeditious for the commission to have everybody on at once, but I think it is definitely better for the attorneys and the parties to know that there's a certain time period in which they'll be called, because otherwise we can't tell them, and that's frustrating for them.
Take the opportunity to use a few minutes to have this conversation. My view is that the bifurcated day still makes sense. I tinker with the time, maybe a little, maybe 12:30 is late, maybe noon is a better time to start a second session. But beyond that, I think I'm a pretty big fan of the idea that any day where, is it 4 or 5 cases is our cutoff? I mean, that's the thing, we have to figure out where the cutoff is. I trust that you certainly did it, in my opinion, the right way this time around, but I think we have a critical number of cases. We should do the bifurcated day.
Sorry, go ahead.
Yeah, I mean, I don't mind doing that, but I think the time ought to be cut down. It ought to be noon, and we ought to front load the morning to make sure that we do efficiently use the time in the morning. I like if there's 9 cases, I think there ought to be 6 scheduled for the morning and 3 in the afternoon. Or if there's 8, 5 and 3, or 6 and 2. So that, we're sort of splitting the issue of not just taken by half, because I think it'll happen again that, that we're an hour and a half of dead time.
Either way, someone ends up waiting.
Yeah.
So yes, I will be happy to. Usually I try to judge best case and worst case scenario and land somewhere in between. if I know that folks are definitely going to show up and argue. Sometimes we get unexpected no-shows. So
Right.
I appreciate your comments, and I will try to do better next time.
I don't think you should do anything different next time. I think you did great. And I would have broken this day up the way you did as well. I do think though, Ed, that noon time makes more sense. I don't know, Julie, if you have an opinion, but maybe noon on a five case morning, noon time probably is better. I think that's where I land. And then I do defer to you though, Amy, you and Barbara and your investigators probably know which cases where there's an attorney, and sometimes that changes how long a case is, where there's issues that might, and materials submitted that might mean the case is going to take longer to hear. I mean, these things better than we will. So I'd like to leave the authority in your hands to schedule these. But my general hope is that you would try to avoid longer than 5 case mornings, and then try to divide the day around noon. I think Amy just quit. That's unfortunate.
Yeah, especially because she and I have a deal. This is
Right.
not permitted.
Did I say something? I mean, I thought I wasn't being very rude.
You were not. I also don't understand why poor Angela has to be the host now.
Amy just left in a huff. All right, well, I guess.
All right, time to go.
We're close to starting, but we will certainly wait for the return of our director before we move on. So for those of you that are here for the afternoon session, just bear with us for a moment. We're having a Zoom technical difficulty at the home office.
Actually, I think a substantial source of the problem is that Amy is not at the home office. She is out in California dropping a child off for college. So there may be something that happened to her Wi-Fi that we don't know about. I'm going to text her now.
It's a big country.
All right, sorry.
You were back, then you froze, and then you disappeared.
Well,
No, she was trying again.
Here
Yeah,
she comes again.
Sorry about that. Somehow my phone, my work phone, the Wi-Fi thing was not stopped working. So sorry about that. And I don't know how reliable this Wi-Fi that I'm on is, but I guess we'll find out.
Yeah, if we lose you, I can just
You just keep going.
muddle along.
All right, that will be our rule of thumb then. We'll start this afternoon's agenda with the next case on the docket is E20-0464 Boyce versus Walgreens. That is, excuse me, forgive me. That is a reasonable grounds finding, and as a result, we should be hearing from the respondent in this case. Is the respondent's representative here?
Yes, good afternoon. David Metz on behalf of Walgreens.
Hello, Mr. Metz. You have 10 minutes.
And before any of the parties get started in the cases, and maybe I missed you doing this already, Jeff, I just want to remind everybody in every case not to use the names of any third parties. If there's anyone who's not a party, we've given them a pseudonym like supervisor or nurse in our report.
Good point. And also, forgive me, Mr. Metz. Do you think, in light of the fact that we have two sessions, that we need to give the spiel again?
I do.
Again? All right,
Yes, definitely.
Sorry,
a lot
Mr.
of folks
Metz.
here weren't there.
Forgive me. I am Jeff Ashby, and on behalf of my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of this afternoon, I'm asking each of you that have an electronic device to keep that electronic device off. The best rule of thumb is to keep your microphone muted on Zoom until you're asked to speak. We have additional agendas, including the consent agenda. They've been available, I guess, online. You probably should have that by now. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted period, and we voted earlier today on those cases, and they won't be considered further today. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time, but no new information or any written materials will be accepted today. Cases are going to be called in the order on the agenda. As I call each case, the party who has submitted a written argument will be called to the podium, will be called upon to provide the most relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only 1, relevant factual errors, 2, relevant omissions from the report of facts submitted during the investigation, or 3, relevant issues and questions concerning the interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. Please be advised that commissioners may ask questions and introduce yourself as we, and you already have Mr. Metz, but introduce yourself as we introduce you. Thank you.
So
Now.
yes, go ahead.
Well, I was going to say now, Mr. Metz, you have 10 minutes.
Okay, thank you. Thank you, commissioners. I don't know that I'll use all of my 10 minutes. I'm happy to use, I guess, as much or as little of it as needed. We've thoroughly set forth our position on this case in the March 22nd, 2021 position statement that we initially submitted, and then more recently in the July 18th, 2022 statement of disagreement with the investigators report. And I don't want to, take up everyone's time by just regurgitating kind of everything that we set forth in our statement of disagreement. But I guess in short, the report accurately sets forth the law in this case, but totally misapplies the law to the facts of this case, and in effect imposes a standard on Walgreens that's simply not supported by the Maine Human Rights Act And basically what that is the report finds that Walgreens should have afforded preferential treatment, more favorable treatment to the complainant here by excluding her from the reduction in force at issue in this case because of her gender, or because of the fact that she was pregnant at the time the reduction in force was occurring. And that is simply not required by the Maine Human Rights Act. The Maine Human Rights Act, as you all know, requires that employers treat employees the same and no worse on account of a protected characteristic such as gender or pregnancy. Walgreens in the summer of 2020 went through a nationwide reduction in force for pharmacists in areas that were deemed to be overstaffed. Maine was one of those areas that was determined to be overstaffed with pharmacists. At the time, there were 82 staff pharmacists working in the state of Maine, and the determination was made based on labor budgets, based on staffing needs, that we needed to reduce that number by 27 staff pharmacists. Through a totally neutral selection process that took into account performance and tenure, Walgreens stack ranked the pharmacists working in Maine and basically eliminated the bottom 27 people based on that combination of performance and tenure. And complainant in this case happened to fall in that bottom 27. Complainant was not a poor performer. We've never taken the position that complainant was a poor performer. She received a meets expectations rating on her most recent performance review prior to her separation. But the combination of her performance and tenure placed her in the bottom 27 pharmacists in the state of Maine, and therefore she was selected for inclusion in the reduction in force. The fact that she was pregnant at the time did not require Walgreens to exclude her from the reduction in force. And that seems to be what the report is concluding, because there is absolutely no evidence to support the conclusion that complainant's gender or pregnancy was a but-for cause of her being included in the reduction in force or played any part whatsoever in the decision to include complainant in the reduction in force. The report several times notes that Walgreens knew of the fact that complainant was pregnant at the time of the reduction in force and knew that she was scheduled to begin her maternity leave very shortly after she was notified of her separation. We don't argue with those facts. Those facts are accurate, but those facts do not establish that therefore her pregnancy and her gender were the reason for her separation, the reason for her inclusion in the reduction in force. It's a jump that is not supported in any way by the evidence in this case. And again, what the report seems to be suggesting or concluding is that Walgreens had some type of affirmative obligation to remove complainant from consideration from the reduction in force simply because of the fact that she was pregnant at the time it occurred. And again, that is simply not the standard under the Maine Human Rights Act. So with that, I'm happy to answer any questions that the commissioners might have or go into any further detail about any aspect of this case.
Thank you. Any commissioner questions for Mr. Metz? I see Commissioner Ashby.
Metz, missing from, and maybe this is a question for the investigator, but I'm sure you know, or your client knows, missing from the investigator's report and from your response is a discussion of the reduction in force formula used to make the decision to terminate the complainant in this case. I understand it's that 90% performance, 10% seniority formula, but there's no real discussion about how that's arrived at. The complainant indicates I've only had one evaluation, and that was a self-evaluation done during my entire tenure. And so from her perspective, you can understand that she's not at all clear how she was measured performance-wise, which is such a large part of the formula to determine the reduction in force. And I thought that would be a good opportunity for the respondent in a reply to maybe explain that formula, but I don't see that in your reply. So can you help me understand how maybe a suspicious complainant might say, man, that formula is a pretty challenge, pretty esoteric for me to understand.
Yes, Commissioner. So in our initial position statement that was submitted back in March of 21, we did go into a little bit more detail about the formula that we use as part of this reduction in force. As you accurately noted, it's based on 90% performance, 10% tenure. It's based on a 2-year average of performance ratings. So in this case, we looked at the 2018 and the 2019 performance ratings for the pharmacist and took an average of the two. In complainant's case, she only got a performance review in 2019. She did not have one from 2018. So we exclusively used her 2019 performance rating, which was, again, a meets expectations ratings. She received a score of 3 out of 5 on her 2019 performance review. I don't know what complainant knew or didn't know about that performance review, but that's the rating that our personnel records and our performance management system has on file for her. That's the rating that we have, and that's the rating that was used as part of this matrix selection process.
Just if I could just interject, I understand from the investigator that I believe you've included a lot more detail in your, which you're just answering the commissioner's question, but you've used a lot more detail than was actually in the respondent's pleadings in this case. And I need to ask the parties and the commissioners, which is not the commissioners, didn't know they were asking for anything outside the record, but that we limit discussion to what is in the investigator's record. So thank you. I'm sorry, Commissioner Ashby.
Yeah, I don't know what to do with that, I guess. So if it's in the record, and can you answer whether if in the record, any other objective criteria were used, like economic performance or customer satisfaction or any other information other than, because as I understand it, the one evaluation, and this is in the record, the one evaluation that the complainant undertook was a self-evaluation, and she self-evaluated herself apparently as meeting expectations. And as I understand it, this, as you just explained it, this rubric seems to rely maybe even as high as 90% of the consideration is based on this evaluation and maybe nothing more, then and in this case, this woman's evaluation was based on her own words. She's hoisted by her own petard, as they say.
I'm at risk of violating the rule that Amy just laid out, but I'll answer your question as best I can while still trying to stay within the parameters of the papers we submitted. The performance evaluation process at Walgreens involves team members doing a self-evaluation, a self-reflection of their own performance, but then a manager also weighs in, and the performance rating that we used for all of the reduction in force, throughout the country, and in particular in this case, is based on the final performance rating, which is not just the complainant's self-evaluation, but then her actual score is based on her manager's assessment of her performance, which at times can be the same as somebody's self-evaluation. Sometimes it's higher, sometimes it's lower. But our performance management process, it involves more than just somebody's own self-evaluation. It involves their manager's evaluation as well, and that's how the final score is derived, and that final score is what's used as part of this. What was used as part of this process. I guess I can't speak to what complainant knew or didn't know about the performance management process or about her manager's evaluation of her. I guess I don't know that, but at the end of the day, the rating we had for her in the system is the rating that we used as part of this stack ranking. And whether she knew she got a score of 3 on her 2019 performance evaluation or not, it does not, that even if she didn't know that doesn't in any way prove gender discrimination here.
Well, respectfully, sure, but once she makes the prima facie case, and she certainly has a temporal proximity prima facie case, I don't think you dispute that, right? I mean, I think you'll agree that she is a protected person. She had this adverse employment act that occurred. You ultimately had a need for the job to still be done by another person, right? She meets the prima facie case, correct?
I actually would take issue with that, because I think that the final aspect of the prima facie case, whether we had a continuing need for the work to be performed, I don't agree that she's established that. I think that's kind of missing the mark in terms of how the prima facie case applies to a reduction in force situation. We certainly did have the continuing need for staff pharmacists. We just didn't need as many of them. We had too many of them, and we had to eliminate by 27. So yeah, we still
you don't think she meets the last prong because you retained someone who had less seniority than her, who was a male? You don't think she meets at least the prima facie?
But the seniority is not the only question here. Complainants relies only on seniority as the reason to distinguish herself from the male that she claims was treated more favorably, but that male had a higher performance rating than she did, which resulted in that male having a higher reduction in force matrix score than she did. So the reliance purely on that male's seniority is not accurate by complainant.
All right, I have no further questions. Thank you.
Commissioner David?
What's the Attorney Metz? What's the manager's rating for her? That's part of that overall rating of 3 out of 5.
3.
If it's in the record, sorry.
Yeah, if it's in the record.
3.
What would you say to the only input, the only performance rating you're using is the one that she did herself, in which she humbly says meets expectations. She could have said superb or excellent, I gather, and she didn't.
I just want to remind Mr. Metz what limited information respondents submitted to the commission, because you are continuing to give information that is, I believe, not in the record.
Okay, so I guess the
only input she had was the self-evaluation, correct?
That is correct. But that is correct.
And no other evaluations of this employee over 2.5 years, whatever it is?
The only evaluation that we have for her was 2019. because as we did explain in the position statement, she cut over from Rite Aid when Walgreens acquired a number of Rite Aid stores.
And I'm going to ask you not to use the names of third parties who are not a party to the case.
Okay.
Thank you.
She came over from another company that we acquired. And 2019 was our first opportunity to do a full performance review on her.
What was the score of the mail that you retained?
If it was in the record.
It was not in the record.
Thank you. That's all.
Any additional commissioner questions about things in the record for Mr. Metz? That'll do it for now. Mr. Metz, you'll have just over 4 minutes when we come back to you.
Thank you.
Now we turn to Mr. Black on complainant's behalf.
Good afternoon. My name is Eric Black. I'm representing the claimant Ariel Bois in this matter. I do want to note at the start that I am new to the case. I took this case over from another lawyer. I have not been involved in the case from the start through the investigation process. I only came on after the investigation was complete. So there could be some fact-specific questions that I may not know the answer to, but I'll do the best to answer if they come up. Ms. Bois is a Maine licensed pharmacist. She was originally a staff pharmacist at another company, but as the commission may know, in October of 2019, Walgreens completed a purchase or merger with this other company. And then 1 month after that, she found out she was pregnant and was due in mid-July of 2020. It was early, so she waited a few months to tell others, including her workplace, but she did inform her workplace in January of 2020. In April of 2020, she got a new district manager. Her maternity leave was due to start on July 19th, 2020, and she requested to use 2 weeks vacation prior to the start of the leave, so she'd be leaving starting July 5th. June 30th, just a few days before she was due to start her vacation and then, be on leave for several months, she was terminated. And she was terminated, the rationale at the time was budget cuts. It is important to note, as I'll be talking about in just a minute, that a male staff pharmacist, at least one, who was not about to go out on maternity leave for 3 or 4 months and was junior to her, was retained. She did ask about her maternity leave. Her district manager said, "I'm glad you brought that up because I was not allowed to. If you get medical leave from your doctor before July 15th, or if you deliver your baby after that date, you will still be entitled to scheduled maternity leave." She went to the doctor the next day. The doctor decided her to remove from work due to increased stress, obviously having learned that she would be fired. She told that her maternity leave was approved by by another company that contracted benefits manager for Walgreens. July 11th, she delivered her son. And then 5 days later, July 16th, this other third-party company called, said that maternity leave was canceled, effective immediately because you're no longer an employee of Walgreens, having been terminated on July 15th. With a 5-day-old child, this was a terrible position for Ms. Bois to be placed in. Now, to Walgreens' arguments, I don't think that the report concludes anywhere that Ms. Bois should have somehow been removed from the pool, in terms of looking at the reduction of force, although I'll let the investigator speak to that more. But the motivation, there certainly would be a motivation for Walgreens to do what it did here. Assuming their claims about a reduction in force are accurate, it's much more convenient to get rid of an employee who won't be working for a few months anyway than to retain her. It's much easier to get rid of a pregnant person going on leave than someone who is a junior to her and won't be absent from work for the next several months, or be pregnant or be getting pregnant because he's a male. The thing that really sticks out to me is that Walgreens has not presented the underlying data to prove that this was allegedly sex neutral. A male employee junior to her was retained, at least one, and she, a pregnant female, was not. So the natural question is, well, if this wasn't discrimination, then what's Walgreens' explanation for this? And again, the investigator can correct me if I'm wrong, but I've looked through the response of Walgreens, I've looked through their objection, I've looked through the file, and I cannot find anywhere where they produced any documents to prove that this was sex neutral. This jumps on the point that Commissioner Ashby made. a moment ago during oral argument. They've made general statements about the formula, but no underlying data has been produced. It's tantamount to saying, well, this was sex neutral because we say it was sex neutral, you know, in asking the commission to essentially just trust them. There's no dispute that they retained a male employee who was junior to her and who was obviously not going to be going out on maternity leave. And Walgreens says, well, there's this combination of a performance and tenure score, and his was higher than hers. What was it? We don't know because Walgreens didn't say. What was Ms. Bois' score? We didn't know because they didn't say until today, by the way. This oral argument is the very first mention I have, and again, I can be corrected, but this is the very first mention I've ever heard of a 3 out of 5 score or anything to that effect. I don't think it's ever been disclosed before today. We don't know where that came from. I don't know what 3 out of 5 means. I don't know if that's an overall score or if that's referencing specific criteria. I don't know what criteria that's measuring. The investigator's report on its final page, in paragraph 7, says respondent additionally provided no documentation regarding any of complainant's performance evaluations, reprimands, or any other information to indicate that complainant was terminated due to ineffective job performance. And Walgreens would say, well, she wasn't terminated due to ineffective job performance. You know, it just wasn't effective enough, I guess, to get over the cutoff line. But again, where's the proof? None was submitted as part of the record. The secret sauce isn't being shown. There's really no documentary evidence of what it is or why Ms. Bois fell below the mark. Walgreens essentially has asked the commission to take its word for it, which given these suspicious circumstances, it doesn't have to do. And absent that, we're left with a very suspicious termination. Ms. Bois notified she would be fired a few days before she's set to go out on maternity leave, and you know, a male junior to her was retained. Circumstantial evidence is enough, and indeed it would be rare for a large company in 2022 to write down that we fired her and kept someone with less experience because she was pregnant and this was a more convenient decision. But the vague explanation from Walgreens really just doesn't cut it, I would submit. The only evaluation, to speak to the evaluation that what we do know, the only evaluation from Walgreens the entire time she worked there, to Ms. Bois' knowledge, was a simple form questionnaire where she was asked to grade herself. And I think she believes that the superior graded her in some fashion as well. But again, there's a bit of speculation here because Walgreens submitted no evidence as to what the score was, where it derived from, where Ms. Bois fell short. Walgreens, I think, mentioned, just Mr. Counsel for Walgreens mentioned that the company doesn't know what she knew, and because it wasn't disclosed during the course of this investigation. We can't respond to something when it isn't brought to our attention during the course of the investigation, and an investigator can't take it into account if it's not part of the record. But in any event, this evaluation that Ms. Bois went through, there was no meeting, there was no discussion, there was no counseling with her about, you know, that she needed improvement. I don't think they even met to discuss the evaluation. And, you know, so when Walgreens says that they've ranked these individuals according to a performance and tenure score, as it said in the objection, we in this commission really don't have a full picture of what that means. And they certainly had the opportunity to provide that information. You know, the standard letter that goes out from the commission, parties are asked to provide all helpful information. And Walgreens didn't, and the commission has to work with the record that currently exists. It's not entirely clear what her score, how her score compares to this other individual's score. Walgreens says this was a fair and consistent process, but again, with the lack of documentary evidence, there's really no way to back that up. Walgreens essentially is saying, trust us. And you know, this had nothing to do with pregnancy, but I would submit that that's not good enough. So given that, it's not surprising that the investigator found, as I read through here, in favor of Ms. Bois, and we would submit that the commission should affirm that decision. And with that, I'll reserve the balance of my time and try to answer any questions that anyone may have. Thank you.
Thank you. Okay, any commissioner questions for Mr. Black? Commissioner O'Brien?
Thank you. Could you, I'm just trying to confirm, and it just came, the question just came to my mind. Can you, and I'm sorry, I can't find it. Can you confirm that both Ms. Watt and her replacement were both pharmacists, not pharmacist techs or whatever? Are they both pharmacists?
If it's in the record.
If it's in the record.
To the best of my knowledge, and again, this is to the best of my knowledge based upon the information, because much like the commission, I'm reviewing a record too. I wasn't present when it was really created. I believe that to the extent the question is whether Ms. Bois is on equal footing with this same person, this other male individual who we're not naming here, I believe they held the same position to the best of my knowledge.
Okay.
And they're both pharmacists to the best of my knowledge. Staff pharmacists specifically, I think.
Any additional commissioner questions for Mr. Black? You'll have about just under 2 minutes when we come back to you, Mr. Black. And then we go back to Mr. Metz. Mr. Metz, you have just over 4 minutes. And I'm going to ask you again to be familiar with what respondent chose to submit as its submissions to the record, and restrain yourself to that.
Sure. And what we did submit in our original position statement was data, not underlying documentation, but data to show that this was a very gender neutral process. We included statistics in our position statement submitted in March of 2021 to show that for the 27 individuals that were impacted by this reduction in force, 10 of them were male, 17 were female. But for the males pharmacists that were selected, there were 31 total male staff pharmacists in the main area. 10 out of those 31 were selected for reduction in force. And for the females, 17 out of 51 female staff pharmacists were selected for the reduction in force. So those selection rates are basically identical. 32% selection rate for males, 33% selection rate for females. So I take strong issue with the suggestion that there was no evidence of this being a gender neutral process. We did present that. We didn't present, I can't do anything but agree. We didn't present the underlying data, the performance reviews for performance review numbers for everybody who was selected for inclusion and those who were not included in the reduction in force. We didn't present the tenure statistics for all of the pharmacists in the area. That is correct. We did not. We were never asked for it. There was never any follow-up request for additional information beyond what was set forth in our statement of position for further detail or explanation or documentation or anything having to do with the reduction in force. We would have been happy to provide that additional information, but it was never requested, and therefore we were I didn't know that any. I guess I'll just leave it at that. But we did present the information in our position statement about the selection rates for males and females in the main area, and like I said, they were basically identical, showing that this was a gender neutral process.
Are you all set?
Yes, unless there's any further questions from any of the commissioners.
Any commissioner questions for Mr. Metz? Seeing none. Thank you. Mr. Black, you have 1 minute and 50 seconds. 50.
I don't have much more to add. I guess I would just point out that, just because, even if it is accurate that the male and female reduction in force percentages were equivalent, that doesn't necessarily mean that Ms. Bois was not terminated discriminated against on the basis of her pregnancy in this particular instance. And again, assuming those figures are accurate, because again, no underlying data was submitted. And again, I don't have the exact text of the letter that goes out to respondents, but seem to recall it does say something to the effect of, please, this is your opportunity to provide all information that, to show that there's been no discrimination here. So I guess I'll simply leave it at that. Thank you.
Any commissioner questions for Mr. Black? Seeing none. We turn to our investigator, Courtney Byrne.
Good afternoon, commissioners. I was an investigator assigned to this case. And just to start off, I guess I want to touch on the reason why I did not request any additional information in this case. That was because we never received an agreement of non-disclosure from respondent. So there were several requests starting initially with the notification packet that's been referenced a couple of times. We asked for the non-disclosure agreement. We did not receive one. A reminder letter was sent on March 1st, requesting that one was provided by March 22nd, 2021. We didn't receive one. And then when I was assigned to this case, I reviewed the record, did not see agreement of non-disclosure, requested it again, and provided a deadline of April 20th, 2022 to receive that document so that I could conduct an investigation, so I could exchange submissions with respondent. And I never received one, and issued the closed evidence notice April 21st, 2022, and then closed the record March 12th, 2022, just to set the timeline for what happened there, if you had any questions about that. And additionally, I'll just touch on that initial notification packet that's been referenced, requested specific pieces of information, including but not limited to identify all decision makers involved in the decision to discharge, briefly explain the rationale each of them used in his role in the decision, provide statements signed by the decision makers. So that was one bullet point. Additionally, copy of existing evaluations of complainant's work, copy or account of all verbal or written reprimands, warnings, or disciplinary actions issued to the complainant and others in the same job classification in the past 2 years. And then additionally, list other employees who have been separated in the past 2 years. Please denote sex, including pregnancy, date of separation, and reason for separation. Indicate those who were discharged for the same/similar reasons as complainant. So I just wanted to include that information as well, that information was requested, and you've seen the response from respondent. And that was the information that had to go off of based on not having a non-disclosure agreement, and that's why the record was closed. So feel free to ask me any other questions if you have them. Thank you.
Thank you, Courtney. Any commissioner questions for the investigator? Seeing none. Okay, thank you. So commissioners, you've heard from the parties and from the investigator. We have one proposed finding here, so we would be looking for a motion.
I'll move that we find that there are reasonable grounds to believe that respondent discriminated against complainant on the basis of sex.
I would second.
So it's been moved and seconded to find reasonable grounds based on sex. Is there any discussion among commissioners?
It seems fairly straightforward to me, and I think Attorney Black is correct when he refers to them holding the secret sauce. There's no criteria as to what those evaluations are, and we can't second guess that. This mediocre employee is offered a $30,000 bonus a few months later. I think it's clearly discrimination based on her pregnancy status.
Any other discussion among commissioners? Seeing none. Hold on, I'm doing too many things at once. So the motion is to find reasonable grounds to believe that respondents subjected complainant to discrimination based on sex, and conciliation should be attempted. If you're in agreement, please indicate yes, both visually and auditorially. Just to mention for all the folks on this afternoon's hearing agenda is that we are required, because we are doing remote hearings, to be able to both see and hear every vote from commissioners. So Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
So the finding is reasonable grounds to believe discrimination occurred. The commission will send both parties and council a letter confirming that and discussing the next steps. We thank you for participating this afternoon. And that hearing is concluded.
Okay, next on our agenda is MRC number H220114 AB.
Commissioner, I think we actually skipped one.
Oh. Hold on.
Sorry.
Forgive me. No. Did we? Oh, yes, I'm sorry. Thank you. Next is E20-0473. That's Harris versus Walmart Sam's Club. That is a no reasonable grounds case, and as a result, we should hear from the complainant or the complainant's representative first. Is there someone here on behalf of the complainant or the complainant himself?
I believe Mr. Harris is here.
Yes, I'm here.
Mr. Harris, you have 10 minutes.
Well, while working for Walmart, the dates and everything lines up. I'm not good with numbers like that, but while I was working there, I needed help with the cash register while getting help, asking the woman that was over on the other side of the cash register to help me. She said, well, just call the supervisor over. She ended up getting the supervisor for me. When the supervisor came over, I explained that this woman has a card that I don't know how to run through this machine. She was talking about a gas card or something like this to get money off of it. So she was like, well, not the respondent, but the person, this supervisor, I don't want to say names.
Thank you. I appreciate that.
You're welcome. And she comes over and she's you guys said that there's no reasonable grounds for anything, but I mean, she was asking me to press a button, and I kept explaining to her that there's no button there. Now, at this time, the people in the line were building up. Now, mind you, I'm not trying to, start anything or anything. I mean, I just want to work. I didn't ask for any of this. So the line was getting long, and while the line was getting long, I was like, well, she kept saying, press that button, press that button. Her voice was getting louder and louder. And the people were in the line looking like, what's going on? I'm like, there's no button there to push. There's no button. You're saying push a button there. There's not a button here. So at the last minute, she said, move, I'll do it. And said, you don't listen too good, do you, boy? And the line heard all of this. Everybody in the line heard this. And they all started laughing. Now, mind you, if there was someone black in that line, it would have been a whole big thing going on, you see, because that would have been a defense type thing to come to my defense, feeling that they needed the need to. What I'm trying to say is that the whole situation was to probably invoke me to get upset about something. I don't know what it was all about. I just know that the way she said to me, you don't listen too good, do you, boy? And everybody laughing at me like that. And then she walks away. And when she walks away, I went ahead and told the line, I apologized for everything. And you see, so I'm like, I apologize for everything, but it's like, it's okay. It's all right. And one woman said that she didn't like the way that I was spoken to, and that she'd like to speak to a supervisor. I didn't get the woman's name or anything like that, but I completed the line, you see, and I was calm. I didn't get upset at that time. And I didn't laugh at no, it was not a joke to be talked to like that in front of people like that. You know, I mean, so so I finished the line and I go over to the desk. I close my register down and I goes over to the area where people bring stuff back. And I saw that woman in there also that said that she wanted to speak to a supervisor. She was standing over here. And all I did, I went in and I said, look, can you, you owe me an apology for that. You see, but the way I wasn't loud, but my voice was like high pitch, but my tone was low, but my voice was high pitched. Like, can you give me an apology for that? That was wrong. Like high pitch like that, but not high pitch with my voice loud. So you see, I never disrespected her. She asked me to go inside of a room with her or something like in this. I said, no, I'm not about ready, because that was kind of shisty, the way you tried to make kind of trickery to try to make me upset in front of these folks. See, so I asked her, I said, no, let me speak with someone else. And then that's when I went back into the back room and spoke with the managers, maybe an officer or something, and set me down, and they spoke to me, and I was like, well, I'm not the one that's wrong here. I mean, why is it that you guys got me back here talking to me like I'm the one that's wrong when I'm the one with the complaint? I'm the one that's trying to explain to you guys how this affected not just me. Like I say, it was other people that didn't like it either, but a majority of the people in the line laughed. So when that happened, I'm like, well, what is this about? I mean, I'm gonna have to take this, I'm gonna have to do something about that. You see, so because after a while, I noticed that I stayed there after we talked and everything. I noticed that she was not disciplined. I didn't see it. And furthermore, they allowed her to work around me. I explained that I don't want to be her to work around me if possible, if you guys, because I don't want to have any issues or anything like that. So I was asked to go to another department, and I was like, well, I don't know why I would have to go to another department. She get to keep her position. Why do I have to go to another area less, I would say less fortunate for me? So I ended up going over there to the other department. Then I said, no, this is not right. So I asked to get put back where I was with my cash register area, because this is what I studied on the computer before I started my job. So while I'm working, I hear them, the woman say to someone, looking over at me, the crowd looking over at me, the workers looking over at me, saying about a race card. But I heard it was nonchalantly directed at me, but not directly to me. But I see them looking right at, like turning their heads. And I'm like, wow, so now it's like a race card thing I'm pulling? So at that moment I said, well, this is not good. I can't work in an environment that's been created to look at me like I'm some type of bad person, you see. So I'm thinking to myself, I need to make this money though. So I stayed through it a little bit longer. And I noticed that she was coming over and was able to work in my area still. You see, so and she's looking at me, but that wasn't in the report. That wasn't in the report. I apologize. But I'm thinking to myself, well, hold up, something's not right. This is total disrespect. But I'm thinking, why is it that she still get to work after it's clearly, it's a video to show all of these things. I'm sure it's a video that shows all of this. And I haven't seen the video, I haven't seen none of that. You see, I don't know what's going on. I don't have money. People lawyering up, and I'm calling lawyers and I couldn't even get a lawyer. The same, matter of fact, I'm like, wow, why can't I get a lawyer? I have a little, stuff put away so I could be able to, help myself. But I figured, well, this is just the way the world is. This is what my thinking is. But the thing is about this whole thing is that it bothered me to the point where I don't even go to Walmart anymore. And I don't even show up at Walmart anymore because of the way I feel. See, I don't know if people know how that feels to be looked at a certain way, like everywhere. It's bad enough that a lot of stuff happens that people look at and they say, well, he's this way as soon as they look at you. But when
Mr. Harris?
Yes.
I'm really sorry to interrupt you, but that is your 10 minutes.
Oh, okay.
I'm just going to check and see if any commissioners have questions for you.
Yep.
Are there any commissioner questions for Mr. Harris? I don't see any.
Yeah.
So thank you. Now I'm going to turn it over. Now Walmart gets a chance to respond.
Yeah.
So I'm going to put you on mute, which I do to everybody. So then we're going to turn to I think it's Mr. Powell. Yeah.
Yes, it is. Thank you very much.
Yeah. Go ahead, Mr. Powell.
Hi, good afternoon, commissioners. My name is Tim Powell on behalf of Walmart. Thank you for your time and attention to this case. With all due respect to Mr. Harris and his presentation today, there's really nothing that's been presented in his submission or statements today that I think should alter the well-reasoned conclusions of the investigator here. The facts of this case are fairly straightforward, and they're largely undisputed by the parties. On August 1st, 2020, Mr. Harris raised a concern to store management about a single comment made by a fellow associate as she assisted him on a cash register. And you heard from Mr. Harris about his recounting of that incident today. The reality is that Walmart took prompt and appropriate action in response to this concern. The incident was immediately investigated at the store level, as well as the HR level through the company's ethics line. And management concluded correctly that the comment made by the associate, which she admitted to in large part in substance, the comment was inappropriate, it was disrespectful, and it violated Walmart's respect for the individual policy. And you won't hear me dispute that today. That was the correct decision that they made. Walmart intended to discipline this associate who made the comment, but she resigned before they could do so on August 17th, 2020. Mr. Harris continued to work after this associate resigned until he then voluntarily resigned on August 20th, stating simply that he could no longer wanted to work at Walmart. So during the investigation of this case at the commission, Mr. Harris has now said that he resigned because he overheard a coworker say that he was playing the so-called race card. He admits in his most recent submission that he heard this comment one time. And most critically here, Mr. Harris admitted at the fact-finding conference that he never complained about about this comment or any other comments made by other coworkers to store management. He knew how to do so. He had raised the prior concern at the cash register. He didn't raise any further concerns with management. Even upon his resignation, Mr. Harris stated only that he could no longer work at Walmart, didn't make any other comments or statements that would have notified store management of these other alleged comments that were made. Mr. Harris also admitted at the fact-finding conference that he requested to no longer work at the front end of the store. And so he was in conversation with the store manager. He was moved to another area of the store. He requested to move back thereafter. Mr. Harris also admitted at the fact-finding conference that he and the associate at issue here had no further communication after this incident. So the investigator got to the crux of the legal issue here, which is when no tangible adverse employment action results from the alleged incident, the employer has an affirmative defense of demonstrating that it exercised reasonable care to prevent and correct promptly any harassing behavior, and that the complainant unreasonably failed to take advantage of any preventive or corrective opportunities by the employer or to avoid harm otherwise. That's the legal standard here. That's precisely what happened here. Walmart took prompt action to investigate and to address this initial incident. Mr. Harris appears now to focus on the aftermath of that incident, with the allegation of another comment made by a coworker, but Mr. Harris never reported this comment to management. And as I mentioned before, he knew how to do so. Just days before this, he had spoken to the store manager about the initial incident at the cash register. And so Walmart simply can't be held responsible here for addressing comments of which it was never made aware. And so for these reasons, I urge the commissioners to adopt the well-reasoned investigative report in this case, and find that there's no reasonable grounds to believe that Walmart discriminated against Mr. Harris on the basis of his race. Thank you.
Thank you, Mr. Powell. Any commissioner questions for Mr. Powell? Commissioner Ashby?
I do, but maybe if someone else has questions, they can ask first. I'm looking for something in the record and I don't want to hold people up. So if anyone else has questions, they can jump the line. Otherwise, wait for me just for a moment, please.
Any other commissioner questions for Mr. Powell from Commissioner O'Brien or Commissioner David? Okay. Then we will wait.
I found it. Hi, Counselor. Sorry for the delay.
No problem.
So in the investigator's report, it's indicated that the supervisor who made, she was a supervisor, correct? Not just a co-worker, but a supervisor who made the comment.
Well, she was, yeah, she was I believe, what's her title? Cash register manager. But I could be wrong on this, but I don't believe she was Mr. Harris's direct supervisor.
In any event, she left, she resigned, it says here, prior to being disciplined. Do you know if the record does say, was she aware that she was going to be receiving a discipline?
I'm not sure if that's in the record. What I'll point to, I imagine what your question is getting at is there evidence of that Walmart intended to take this action? And within the record, there are statements from the assistant store managers that Mr. Harris spoke to. You can tell from their notes from these meetings that they, agreed with Mr. Harris that they understood his concern, agreed it was an inappropriate comment, and they were, was our statement in the position statement that it was Walmart's intention to issue discipline to this associate.
Issue her a disciplinary action for her inappropriate comment, And obviously she was aware she's being investigated because her explanation for the comment, her admission to a point of making some version of that comment,
Correct.
Including the most offensive portion of it. That all happened, but it does indicate the report indicates Store decided to issue her a disciplinary action for her inappropriate comment, but CSM resigned prior to being disciplined. Is that your understanding?
It is. Yes, that's correct.
So this incident took place on or around August 1 of 2020, correct?
Yes, correct.
And it looks as though this CSM resigned her employment on August 17, 2020, some 16 days later.
Correct.
Is that your understanding?
Yes.
And somewhere in those 16 days, at least according to the complainant, she's out running around saying that he played the race card. Do you accept that that happened?
I don't accept that the record supports that it was this same associate that said it. I'm not sure. I think there's been various statements made by Mr. Harris about this allegation. I also take issue with, running around and making these comments. In Mr. Harris's most recent submission, it was the handwritten submission submitted prior to this hearing. He admits that this was a comment made on one occasion. And I understand, he explains that the repercussions of this comment, this alleged comment in his mind, kind of reverberated in his own mind, but he admits that this was a comment made one time. And I don't believe he ever assigns it to that same associate.
I see
other than his statement today.
Well, I see on page 5 of the investigator's report, it says in the middle of paragraph D, he believed that others, allegedly CSM and or other coworkers, were later discussing the fact the complainant was trying to, quote, play the race card. You haven't presented any evidence to rebut that or anything that in the record, correct?
Apologies, can I just get that reference again to the investigator's report?
It's on page 5 of the investigator's report, the second full paragraph on that page.
It's 6D, paragraph 6D
Okay.
of the analysis,
Okay,
about halfway through.
okay. Okay, and what is your question?
Well, just did you see any evidence in the record or present any evidence in the record or during the investigation to rebut that CSM herself didn't say or said the playing the race card comment?
I'm not sure there's anything specifically in the record to rebut that. This again, though, these comments that I think the most important fact here is these alleged comments were never raised to Walmart during Mr. Harris's employment. There's no way that Walmart could have investigated this timely. This has come up as an allegation during this commission investigation, but was not something Walmart was aware of at any point during Mr. Harris's employment, and therefore couldn't have done anything about it.
Right, but assume a hypothetical with me just for a moment. Assuming hypothetically that Mr. Harris experiences at his workstation this comment where the offensive comment was made, and your respondent investigates like they should, and they apparently commence a timely investigation, but they wait some 16 days before doing, in fact, they wait indefinitely to discipline the person who very clearly requires discipline in this case, who created allegedly the hostile environment. They wait so long that in fact she's gone. She's no longer employed there. But in the course of those 16 days, she continues with behavior that is hostile to the complainant. Would you say in that hypothetical, assuming all those facts are true in the hypothetical, would you say that Walmart in fact then did timely respond to the complainant's complaint? Did in fact Walmart meet its obligation under the hostile work environment analysis to stop the problem once it learned about it? It sounds like the respondent didn't in fact stop the problem, and it continued, so much so that there's a credible claim here that Mr. Harris is constructively terminated.
Well, I take issue with your characterization of Walmart waiting during this period. I mean, these investigations do take time. And I would submit that 2 weeks is not an extraordinary amount of time by any stretch of the imagination in order to conduct an investigation, speak to witnesses, and make a decision with various levels of management and HR all involved. And so there was no deliberate or otherwise delay taken by Walmart here. We also have a complainant who had raised a concern earlier on August 1st, was able to speak to managers about this, and he knew how to report any further concerns and should have done so. It would have been reasonable for him to do so, to raise any further comments that he overheard to those store managers, knowing that this issue is being investigated. Would have been highly relevant to the investigation if they had in fact occurred.
Maybe I'm sounding argumentative, but wouldn't it also be reasonable to for a complainant in the complainant's position to feel that nothing was getting done, that the problem was continuing, and that the only answer was to quit? Isn't that also a reasonable response?
I disagree. I think Walmart has, you can see the notes in the record from the assistant store managers that Mr. Harris spoke to. There's no indication there that there is any lack of concern or consideration for what he raised. They are, open to hearing from him. There is also, there's a separate avenue for employees to report concerns up through HR. There is an ethics line that can be called, which Mr. Harris knew about through receiving the employee handbook. There's many avenues here he could go. Even if he felt uncomfortable with store management, there's other ways he can go to report these further concerns. And again, I'm saying concerns, but it's concern plural. He stated in his most recent submission, this was one comment about the race card at most, that he never reported. So I do not believe that is legally sufficient for a constructive discharge. Particularly when his voluntary resignation was after this associate had left. The associate was allegedly raised these concerns. She had left.
Okay, thank you.
Thank you.
Any additional commissioner questions for respondent?
Is that me?
No.
Okay.
I'm sorry, the respondent is Walmart, Sam's Club. So you already used all your time to present, so there would not be any questions for you, Mr. Harris.
Oh, okay.
So I'm asking commissioners if they have any additional questions for Walmart at this time. No additional questions for Walmart. Okay, thank you. And Mr. Harris did use all of his time. So what we would do now is turn to the investigator, to Robert Beauchesne. Ivan. Nope, you're muted.
There we go. Hopefully that's a little bit better. Good afternoon, everyone. Just to touch on a few facts in this case, excuse me, as the record reflects, the complainant alleged she was subjected to an offensive race-related comment by a supervisor. He reported that the same day after he asked the supervisor for an apology. During the subsequent investigation, the supervisor admitted to making the offensive comment, but denied that she intended or understood any racial connotations to it. Respondent did allege that they made the decision to discipline supervisor, but she quit before the discipline was issued. I think you have the timeline correct. The incident occurred on August 1st, and the supervisor walked off on August 17th. The complainant quit 3 days later on August 20th. again, alleging that he had heard other staff discussing that C had complainant had played the race card. It's unclear how many times complainant heard coworkers having this alleged conversation about the race card. In his answer rebuttal, he claimed that this occurred on a couple of occasions. In the submission in opposition to the report, he claimed that he only heard that conversation once, but quote, it was repeated over and over in his mind. In either case, as respondent noted, complainant admitted he never reported that issue to management prior to his own resignation. So here it's undisputed that complainant was subjected to a highly offensive comment, but it's also undisputed that respondent began an investigation either on or within days after the incident was reported, and that it did conclude that discipline appropriately was warranted in this case. So as respondent noted, this appeared to satisfy the law's requirement for a swift, appropriate, and corrective action in response to the discrimination complaint. And just to tie up one of the loose ends, there was nothing in the record, nor based on questions asked at the fact finding that would reflect that supervisor's comments was due to a lack of training by the store, or that she had any prior history of making such comments that should have alerted the store that there may have been a problem here. So again, while fully agreeing that the single comment was highly offensive, I found nothing in respondent's actions except for, again, an appropriate response to an agreed disturbing statement made by one of its supervisors. To address some of the questioning that went back and forth, again, it's unclear whether or not the supervisor was involved in any of these post-incident conversations about the race card. In complainant's original complaint, as well as in his rebuttal, he confines the discussion solely to coworkers. It was only at the fact-finding conference, I quote, I asked whether or not he had any further conversations with the supervisor, and he said no, but he did hear her say something about the race card to two coworkers. So the record is a little unclear whether or not she was ever involved in these coworker discussions or not. But again, the end result would appear to be the same. The store was never put on notice that that was an issue, so was given no chance to investigate. So that's really all I have to offer, available for any questions that you might have.
Thank you, Bob. Commissioner questions for the investigator? Not seeing any. Okay, guess that's all. Thank you, Bob. So, commissioners, we've heard from the parties, you heard from the investigator. Oh, Bob, okay. And there's one proposed finding, so we would be looking for a motion.
I'll move that there are no reasonable grounds to believe that the respondent discriminated against complainant on the basis of race and or color, and that the complaint should be dismissed in accordance with the act.
Second.
I want to be heard on the motion, though.
Yes.
Mr. Harris, I believe every word you said today. You testified in a way that was very compelling. My sympathy is with you. Your testimony reflects just how visceral and real and extreme the hurt is from racist acts. I don't remotely believe that any person doesn't understand the connotation of the word boy when speaking to an African-American. That was a racist statement. You're not prevailing today, at least before the commission, because of some legal technicalities. Walmart, or the respondent, is able to show that they don't have liability for the bad acts of their employees unless certain conditions are met, and those conditions aren't met in this case, that this particular supervisor didn't cause you to suffer an adverse employment impact. And then Walmart the respondent did in fact timely investigate. But that doesn't make it feel any better for you. I'm sure I really feel genuinely bad for you. I wish that you could get an actual outright apology from someone for this. Just understand that I believe every word you said. And by the way, I don't hear counsel for the respondent saying that you're not telling the truth. I think he also suggests that you're telling the truth here today, just that what you're complaining about doesn't rise to the level of a violation of the Human Rights Act in Maine for technical reasons. I think counsel for the commission won't be mad at me for saying those statements. Those are factually accurate, I hope, and legally accurate statements. And good luck.
Thank you, Commissioner. Commissioner David?
I won't repeat all of that, Mr. Harris, but I agree with Commissioner Ashby. The comment was vile and racist. You have to understand that you're dealing with legal standards that give a massive employer like Walmart some leeway of a few days to investigate. They didn't take any action adversely against you. They did investigate, and they also have to have an opportunity to investigate the subsequent allegations, which maybe you did not know. So you're not prevailing because the comments were not offensive and hurtful to you, but because of the legal standards that we have to enforce.
And if I may, I just want to add one more thing before Julie speaks. I'm sorry, Commissioner O'Brien. You had said in your comments that that's the way the world works. And I got to tell you, and of course, this decision today isn't going to make you feel any better about that, but I got to tell you, that's not how the world works. And that you should always speak up as you have here today. We heard you. I know Walmart heard you. And it is not acceptable in society to be spoken to the way you were spoken to in this case. So.
Thank you, Commissioners. Commissioner O'Brien, did you have your hand up? I'm sorry,
Yeah.
I did not. Okay.
Yes, yeah. I just wanted to echo that. And you made a comment earlier, Mr. Harris, about an attorney, not being able to get an attorney. I actually don't believe that would have made a difference in this case, because it is a standard that we have to follow. It is in the law. Again, I agree with Commissioner Ashby and Commissioner David. We believe you. No one disputes it, and it was offensive and extremely offensive. And we hope that you understand this.
Thank you, Commissioners. So I think it's probably appropriate to vote. Did we already vote? We didn't already vote. To vote. I think there is a motion, and it was seconded, and that was the discussion among commissioners. Any additional discussion among commissioners? That's clear. I don't see any. So the motion is to find no reasonable grounds to believe that Walmart Sam's Club discriminated against Mr. Harris on the basis of race or color. And if you are in agreement with the application of the legal standard, if not how it feels, please say yes and indicate that visually. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Thank you. And I just want to say, I don't think I have ever heard all of our sitting commissioners address the complainant in that way, in a no reasonable grounds case. So, Mr. Harris, I hope you at least walk away with this knowing that you were heard, if not a decision in your favor. So I know we've said lots of things to you, and you are not expected to respond in any way. So that is the end of that hearing. The commission will send a letter to the parties and council confirming the results, and we thank you for participating today.
Can I take this to civil court?
The letter that we send you explaining, confirming today's result will give you a little paragraph about if you want.
This is not cool. I'm not going to stop and I will not stop. Because if it happened to me, it's going to happen to others also, and they're going to get away with it again. So something needs to be done. about that.
So the letter
don't
that we
see-
send you, we can't assist you in any way, just like we can't assist Walmart. But the letter that we send you will give you the time limitations for pursuing this in court. And I thank you
I'm going
for
to Boston.
participating.
I'm
I'm
taking it
sorry?
to I'm taking it to Boston. I'm not staying here. I'm gonna be moving to Boston real soon here.
All right,
Thank
thank
you
you,
very-
Mr. Harris.
thank you.
The next case, I think we're ready for our next case, which I called once already, is H22-0114 A and B. It's a dual filed HUD number 01221227 and 8. Fake, I'm sorry if I
Wait.
pronounce it.
Wait, hold on. Commissioner, I apologize. We actually are, the one that you called was HPA 220074.
Holy cow.
It's hard to keep track.
No, he didn't.
He didn't call that one?
No, he's calling 0114, H220114.
Okay, but that's not actually the next case.
Oh,
He's
I
on the
have,
list.
sadly, my list of cases doesn't match the agenda. Hold on, let me look.
Yeah, it is on the list. Amy, I understand why he called that.
Ah, okay. You're right. Oh, yes.
I'm not sure.
We had H201 listed last on the agenda, but not last on my list of cases. Sorry about that. Again, my apologies. We are calling HPA 22-0074 Miller versus Wallace. And that case is a no reasonable grounds case, and as a result, we should expect to hear from the complainant or the complainant's representative. Is Mr. Miller or your representative, Mr. Miller, here?
I don't see Mr. Miller's email on here, and I am not aware of him having counsel.
He doesn't have counsel.
Okay. So I believe, oh, I'm sorry.
I do see Mr. Wallace here.
Yes, Mr. Wallace is here, and so is his counsel. But I don't see anyone for complainant.
Okay.
In which case,
I'll entertain a
typically,
motion.
yeah, that we would typically go to a motion.
And I'll move that we take them both together and find that there's no reasonable grounds to believe that respondent discriminated and no reasonable grounds to believe that respondent retaliated, and the complaint should be dismissed.
I would second it.
So it's been moved and seconded to find no reasonable grounds on both discrimination based on disability or sexual orientation and also based on MHRA retaliation. Is there any discussion among commissioners? Seeing none, if you are in agreement with the both proposed findings, please say and indicate yes. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
So both findings are no reasonable grounds, and the commission will send parties and counsel a letter confirming that. And we thank respondent and his counsel for being here. And then we're on our last case.
For the third time today, I'm going to attempt to call case number H22-4114 A and B, dual filed with HUD 01221227 and 8. That's, forgive me, Fakori versus Lebel. That is a reasonable grounds case, and as a result, we should hear from the respondent or his.
There's two respondents, Commissioner.
Or their, sorry, counsel.
I'm
And I believe-
sorry, I don't have the case that you're calling.
You don't have the case?
Well, isn't it H22-0114?
It is.
Yes.
Yeah, okay. I'm sorry. You confused me about the two findings. Yes, I have that, sure.
Okay, so I believe Ms. Tibbetts is here on behalf of the respondents.
Great.
Ms. Tibbetts, you have 10 minutes.
Good afternoon, commissioners. I am here representing both respondents, Burnham Brookside LLC,
Wendy, and I'll refer to her as Manuel, which is actually her current name, who is an employee of HPB Apartments. So Burnham Brookside LLC is the owner of the multi-unit residential building in Scarborough, which is in part the subject of this complaint. Respondent Harold Burnham is the sole member of the LLC, and Mr. Burnham has owned and managed residential rental properties for over 30 years.
I'm sorry, Ms. Tibbetts, I don't want to interrupt you, but the named party is Burnham Brookside, so I would encourage you not to use the names of anyone who is not a named party.
Sure, thank you.
Thank you.
Wendy Manuel is an employee of HPB Apartments, and she is the manager of Burnham Brookside, the apartment building owned by Burnham Brookside LLC. Ms. Manuel has been in the property management and residential leasing business for over 25 years. Complainant in this case applied for an apartment at Burnham Brookside on December 22nd of 2021. At that time, the only unit available was a studio unit with a rent of $895 per month. Burnham Brookside offers workforce housing in Scarborough at a price point that's generally targeted at less than $1,000 per month, and HPB Apartments receives an extremely high volume of interested applicants in these units as a result. In this case, complainant applied for the studio during the peak of the Omicron variant of COVID-19 in late December 2021, and I say that because in response to the ongoing pandemic, Ms. Manuel attempted to limit the number of showings that she was conducting in person for each unit at this property and others that she manages. Upon receipt of each application, she would conduct credit checks of the applicant to ensure that she was scheduling showings only to those applicants who could meet the minimum credit requirements for renting the desired unit. Ms. Manuel received complainant's application on December 22nd, which was incomplete at that time. The application asked for proof of income and/or employment, but it did not include any income or employment information and stated only that complainant was a full-time student. There was no cosigner identified and no information as to how complainant intended to pay for rent for the unit. The complainant signed the application form acknowledging expressly that acceptance of her application did not guarantee housing. Consistent with her practice, Ms. Manuel conducted a credit check and notified complainant on December 23rd, the following day, that she had approved her credit and could schedule a showing of the available unit. Ms. Manuel then agreed to meet complainant for a showing at 4:30 p.m. on December 24th. The listing for the apartment at Burnham Brookside specified under pet policy that only cats are allowed. And at that point, based on her application for rental unit and the listing, having been in response to the listing, complainant was undeniably aware when she applied for housing at Burnham Brookside that dogs were not allowed, and that she would need to request an accommodation to that policy for a service animal. However, the fact of whether complainant did so is the key dispute in this case. And the investigator's report ultimately turned on a credibility determination as to that fact, which is our most critical concern with respect to the finding. Respondent's position has been and remains that complainant did not notify them of her service animal or request an accommodation from the pet policy until 5 days after the showing of the unit, at which point the unit had already been rented to another applicant who previously submitted a complete application, unlike complainant. Our position is that the investigator erred in making this credibility determination. For example, our statements have been throughout that during the showing, Ms. Manuel recalls complainant saying, "Oh, did I mention I have a dog?" Ms. Manuel responded by notifying complainant that dogs are not permitted. Complainant requested that she speak to the owner and their insurer about her dog, and Ms. Manuel was confused by this request. At no time did Ms. Manuel understand that complainant was requesting to have a service animal live with her. Complainant did not use the term service animal or assistance animal during the showing, nor did she state that she was requesting an accommodation to the pet policy when Ms. Manuel referenced it in response. Ms. Manuel did not have any reason to believe that the dog complainant referred to was a service animal or an assistance animal, nor any cause to ask complainant if that was the case. They completed the showing on December 24th, and Ms. Manuel did not hear further from complainant for 5 days. Further, the record clearly demonstrates that complainant intentionally withheld information regarding her service animal prior to the showing. Complainant's father stated in the record that he encouraged her to notify Ms. Manuel sooner, and she refused to do so. In light of this, we are troubled by the determination that complainant was found to be more credible than Ms. Manuel as it relates to a critical fact that's in dispute in this case, That is, whether complainant notified Ms. Manuel during the showing that she was requesting a reasonable accommodation for her service dog. The evidence presented by complainant's father in this case shows that there isn't strong support to believe that complainant was forthcoming during the showing. She misled Ms. Manuel during the showing by referencing a dog, and only after she did not hear from Ms. Manuel did she refer to her service animal in an email on December 29th, which again was 5 days later. When she didn't hear further from complainant, Ms. Manuel then rented the apartment to someone who had already submitted a complete application with proof of income. In the current rental market, it should be no surprise that a unit in a new building in Scarborough for $895 a month does not remain available for 5 days. There were a number of other applicants for this unit, and at least 2 of those applicants had already submitted complete applications. The reality is that the complainant did not submit a complete rental application. She could not have rented the unit without this information, and the discussion regarding her dog during the showing had no bearing on that outcome. Mr. Burnham Brookside and the owner of Burnham Brookside reviews and approves all rental applications. He did not even receive complainant's application in this case for review because it was not complete. The investigator found that the correspondence following the showing, the email correspondence, to be contemporaneous communication, which obviously was considered a factor in favor of complainant's credibility. However, respondent has consistently stated that this email was not a summary of the discussion during the showing and did not accurately reflect that conversation. This email presented new information 5 days after the original discussion and was simply too late in terms of the application at that time. Complainant also provided a service dog verification form for the first time on May 25th after filing this complaint. The form is dated November 11th, 2021, and it is clear that complainant was in possession of this form prior to her viewing of the apartment on December 24th. But again, she chose not to provide that information to Ms. Manuel for her consideration of a request for an accommodation. Ms. Manuel, on the other hand, has been renting residential units for 25 years and has never been the subject of such a complaint. Ms. Burnham Brookside and the owner of Burnham Brookside, who owns multiple other rental properties, testified that he estimates he has processed 5,000 to 7,000 applications over 30 years in this business and has similarly never been the subject of such a complaint. Both have testified that they have made accommodations whenever they are necessary for multiple tenants over the years and are always willing to engage in the process to consider such a request. The record clearly demonstrates that complainant withheld that information that would have been otherwise enabled Ms. Manuel to engage in the interactive process to evaluate a request for a reasonable accommodation. From Ms. Manuel's perspective, the complainant was requesting a pet. There was no information provided by complainant that would have prompted Ms. Manuel to review that request as a reasonable accommodation. However, the investigator found that complainant told Ms. Manuel that she required the use of an assistance animal, thus informing her that she had a disability. We simply disagree with those facts. The credibility determination on which this finding was based did not take into account complainant's admission that she decided to withhold the information related to her service animal prior to the showing, that complainant submitted an incomplete rental application, or that Ms. Manuel had been engaged in this business for over 25 years, has made countless accommodations, and has never received a complaint regarding a failure to do so. The Maine Human Rights Act states that it is unlawful for any owner, lessor, or managing agent to refuse to permit the use of an assistance animal or otherwise discriminate against an individual with a disability who uses an assistance animal. An accommodation has to be requested or known in order to refuse to permit the same. The question in this case is whether that request was actually made known to the respondents, and we believe that the investigator erred in finding that it was. Thank you.
Thank you. Questions for Ms. Tibbetts from commissioners? Commissioner David?
Attorney Tibbetts, in what way was the application incomplete in your view?
The application requests proof of income or employment or other sources of income to pay rent, and there was nothing stated on the application. So there was no information with respect to the income to pay for the unit.
And yet the respondent accepted the money and gave a receipt for it.
Respondent did not. That fact is also in dispute. That complainant has alleged throughout that a security deposit was provided. Respondent's position has been throughout this case that a security deposit was not provided or accepted.
Commissioner David, are you all set? Okay. The other commissioners, I think I saw Commissioner O'Brien. Commissioner O'Brien?
I might have, my phone's ringing, so I might have. to
Oh, okay.
mute my phone.
Oh, okay.
Apologize, but I do have several questions. So Jeff, do you have any? I apologize. Okay.
Hello, we can't come to the phone right now. Please leave your name, number, and a brief
I
message.
apologize.
I'll call you back as soon as we can.
Okay. I apologize. It was scam.
It's okay.
Spam. Both. Actually, I have several questions. I don't know that I actually need to ask them all, but there seems to be a lot of disputed facts, back and forth. And one is that in the investigators, supposed interview, that Miss Manuel, had said, the complainant had said that she told her that legally, she had a conversation with her, that legally service dogs are exempt. I mean, it seems to be a whole conversation about this. And I'm looking at page 7 of the investigator's report. And okay, so that is one. And the other questions kind of pertains to this. You mentioned several times that she's been in the business for all this time, and 25 years, 30 years, whatever it is, and that she has made many accommodations. But do you know if she has made accommodations specifically for service animals or assistance animals, considering also that the animal policy, that it was referenced to us that it just says animals. It doesn't mention, which appears to be against our policy.
Before you would answer, Ms.
Yeah.
Dennis, I would just remind you to consider what is in the record and what is not. Thank you.
Absolutely. Thank you. I will, and just so that I can clarify in response to the first issue that you raised with respect to the conversation that's referenced in page 7. I want to be sure I understood whether there was a specific question there. I understand the question with respect to other accommodations related to the policy and animals, but you had also referred to just generally the conversation on page 7. So please forgive me if I'm missing 2 questions there. I just want to make sure I'm covering them. So I'll answer the last, and then if I've missed another, please let me know. So in response to the specific question as to whether Ms. Manuel has experience with accommodations for animals specifically, 2 things that I will point out that I believe I'm quite certain are in the record. The first is that what we had provided was both testimony and documentary evidence with respect to Burnham Brookside's pet policy. And we did draw the distinction between our understanding of a service animal or an assistance animal and a pet. And that was an important distinction, according to Ms. Manuel, with respect to the conversations that occurred during the showing, that Ms. Manuel's understanding during the showing and during the conversation during the showing is that they were talking about a pet, a dog who is a pet, which is not the same and does not have the same status as a service animal. And there was testimony with respect to Ms. Manuel's, and then I believe also followed up in the submission following the conference prior to the close of evidence regarding Ms. Manuel's experience and understanding regarding service animals and assistance animals and making accommodations for such. I don't know that we specified the types of accommodations, and that was largely in part due to the number of units that Ms. Manuel has experience with, but we did submit written testimony, and Ms. Manuel testified during the conference with respect to her understanding of the distinction between pets and service animals and her experience with making accommodations related to that. But we did not discuss specific examples of that to my recollection in the record.
And then Julie, I'm sorry, Commissioner O'Brien.
Call me Julie. Okay, I'll leave it at that. But the other issue is, I always was under the impression, and in my other life, I dealt with this type of thing, that on a credit report, it used to be that it included employment or source of income. And can you, well, maybe it's not in the record, but can you confirm or deny that?
That was not discussed. The credit report was not discussed in the record. I mean, so I couldn't provide any more detail beyond the fact that it was a credit report. Credit check was a preliminary part of the process prior to a showing. That's all all the credit report was discussed in the context of.
Thank you. Any additional commissioner questions for Ms. Tibbetts? Commissioner Ashby?
Hi, just briefly, Ms. Tibbetts, do you agree that do you agree with the investigator's finding that the complainant wrote on December 29th an email indicating that she wanted to check in with the respondent about the unit, that she claims in the email she had sent a security deposit, provided the money in cash and got a receipt apparently, and then indicated that that money was returned. She mentioned service dogs expressly, and then asks, were you able to reach the owner of the property to clarify this? Do you agree that that email went out to the respondent and that the respondent received it?
Yes, yeah, we have not disputed that email. We agree that the email was received. Our argument has been that the email was 5 days after the showing, and it does not reflect the conversation at the showing. That Ms. Manuel's recollection throughout the case has been, through our written submissions and through her own testimony, that a service animal, service dog, or assistance animal was not specifically discussed during the showing. And so when she received that email on December 29th, that was the first knowledge that she had of the service animal.
And so she apparently disputed many factual assertions in that email, correct?
Correct.
Do you also agree with the investigator's finding that she never responded to that email, ever?
Correct, absolutely. And we did discuss that. We have discussed that both in our written submissions and through Ms. Manuel's testimony at the conference. We discussed the volume of rental units that HPB Apartments manages, and that Ms. Manuel testified that it is not her practice to follow up with every person who she shows an apartment to. That it is an extreme number of people who come in and view apartments, especially given the time of year. We did discuss the fact that this showing was on Christmas Eve, which Ms. Manuel celebrates, that the correspondence occurred between that holiday and New Year's, and it was an extremely busy time and an extremely difficult time during COVID to be managing showings and a high volume of apartment listings. So she was very clear during her testimony that she does not follow up with every person who she shows an apartment to, and that would not be uncommon for her to not respond to text messages or emails for someone who has not rented an apartment.
Okay, thank you.
Any additional commissioner questions for Ms. Tibbetts? Seeing none, you'll have just over a minute left when we come back to you, Ms. Tibbetts. And I would note that we only have, I think, a little bit of time left before one of our commissioners has to leave, and then we would lack a quorum. So I'm going to encourage everyone to try to make sure we can get it done. And now we turn to the complainant, and you will have 10 minutes. And just a reminder not to use the names of anyone any company or individual who is not named as a party to this case. I'm asking you to unmute yourself. You don't have to make a statement, but this is your opportunity to do so. And Ms. Fakori, I am asking you to unmute yourself. If you want to make a statement, you will need to unmute yourself. There you go. Nope, still muted. Sorry. So Ms. Fakori, I'm unable to tell if you want to make a statement or if you are having trouble with technology. I don't know if you have access to the chat function, but you could send a message if you're trying to make a statement. Since I have not received any indication from Ms. Fakori that she wants to make a statement, I guess I'm going to ask Ms. Tibbetts if you want to use your last minute, and if not, then we'll go to the investigator.
No, thank you. I don't have anything further.
Okay. So then we go to the investigator, Kit Thompson Crossman, who is now our deputy counsel, handled this case as an investigator.
Thank you very much. I will keep this brief. My name is Kit Thompson Crossman. I was the investigator assigned to this case. The only thing I'll say up front is that a lot has been made about the fact that complainant did not identify the dog as a service animal or an assistance animal prior to signing the security deposit paperwork, which I didn't find surprising, and complainant explained was because she was worried that this would happen and that she would have basically no evidence that it was because of her assistance animal if she said anything up front, and then they just never showed her the apartment or never reviewed her application or found some other reason to deny it. Otherwise, I think I will rest on what I wrote in the report, and I'm happy to answer.
Thank you. Any commissioner questions for the investigator? Seeing none. Okay, well, thank you, Kit. Did someone have a comment there? Nope. Okay, just preparing to make a motion, I think. So we have one proposed finding, and we would be looking for a motion. Commissioner David?
I move that we find that there are reasonable grounds to believe that respondent discriminated on the basis of disability, and conciliation should be attempted. I'll speak to that. If it's
I'm sorry.
seconded.
Jeff, I did not hear that. Did you second that?
Second, yes, sorry.
Okay. So it's been moved to find reasonable grounds, and it's been seconded. Is there any discussion from commissioners?
I think it's quite clear. I think Jeff's, Commissioner Ashby's focus on that email to presume that that was bootstrapping and intentionally misrepresented numerous facts requires a degree of guile that I think our investigator would have detected. So I will go with her instincts and support reasonable grounds finding.
Any additional discussion from commissioners? Seeing none. Okay, so the motion is to find reasonable grounds to believe that respondents discriminated against Shamim Fakori on the basis of disability, and conciliation should be attempted. If you're in agreement with that finding, answer yes, both visually and verbally or auditorily. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
So the finding is no reasonable grounds, and the commission will send the parties and council a letter confirming that and discussing the next steps in our process. And thank you for being present today. That is just in the nick of time, the end of our hearing agenda.
Can we jump over to executive session just for a moment to talk about?
Yeah, Jeff, Ed, do you have a few minutes still?
Yes, she has a note on the door to come in and tell me she's here.
Okay.
So I may disappear, and if I do, it's been a pleasure to see you all, and thank you for the accommodation.
If you disappear, then we have to be done.
Yeah, we'll
because
be
we
done
don't have
if
a
that
quorum
Oh, even for executive session?
Yeah.
for anything, to make any
All right,
decisions or
go ahead
any
and try
votes.
it.
All right,
So
so
one MRS section 405(6)E, I move to go into executive session to consult with our attorney regarding pending and contemplated litigation and the legal rights, and in this case, duties of the commission.
Second.
okay, so it's been moved and seconded. If you agree with going into a second executive session, please indicate yes. Commissioner Ashby?
Yes.
Commissioner David,
Yes.
Commissioner O'Brien.
Yes.
Okay, so I'm going to try to move you all over and we'll see what happens. Anyone else who's left here, we will be back hopefully quickly. Okay. How do I put us back in there? That's interesting. I don't seem to have a way to do that.
You did it before.
I know I did it before, but now it's just saying I can either join it or broadcast the message to everyone. Maybe I closed it before.
Are you still the host, Amy?
That's a good question. I'm a co-host.
So you should be able to.
I agree. I should be able to. I actually put myself in it before by mistake. I'm going to try closing the room and then reopening it. Hold on. I think I never closed it before. All right, now I'm going to move us into it. Okay.
Here we go. You
Yep.
got it.
Okay, we have 1, 2, we still need Julie. So I don't think we require any additional motions or, I mean,
No.
to adjourn or anything. I think we're pretty much set.
But I'm going to take off and be available for my appointment. She's not
All right.
here.
Thank you. Thanks, Ed. We appreciate
Thank
it.
you.
Thank you.
See you
All right,
guys later.
Julie, I think, bye, Ed. I think we're set. We don't need any other motions, so I guess we're just done. Thank
Not
you
even a
both.
motion to adjourn, huh?
No, we don't even need one.
Okay, great.
Nope.
Thank you all.
Thank you.
Bye.
Bye.